is quite legal in most states and quite effective and experiences almost zero fraud. And then you make sure that there are plenty of voting stations around the community in every city, so that in every city, somebody who lives there can go into town and they can vote. This is the way that you manipulate elections in the United States. It's not complicated at all, because they understand that people who are impoverished are constrained by that poverty. Yeah. They're constrained by their distance to the voting places, and what the privileged classes want is for those people not to have a voice, for those people to be invisible.
So in very simple terms, crime is the result of a labyrinth that we are running over, and that's why the same people with the same context keeps being the victims and others keeps being the aggressors.
That's right. All right, so context constraint theory, or constrained context theory, basically says that people are not able to move around the way they want to. People are not able to. Not everybody's equal, and because of their limitations, they make them vulnerable in very specific ways. Their limitations make them vulnerable very specifically. But you do not understand how a person is constrained as an individual until you do their victimology.
Yes.
You do not understand that at all. Another example we can give is I worked a case where a guy was considered to be a suspect for a crime, so the police broke into his home, they shot him, and they hooked him up they had 2 tasers on him, and they were letting him die and hoping he would confess, because they thought he was the guy who killed this young lady and ran away from the crime scene. What they did not understand until days later, but they could see it right in front of themselves, they weren't looking for it, is that the guy had his leg broken in 3 places and he couldn't run. So his constraint at the moment was he was a drug addict, he was poor, he was on the radar of the police already, and he had a broken leg, which meant he couldn't actually physically commit the crime. All right? These constraints are the things that we need to establish. The vulnerabilities and limitations, so that we understand how a person is vulnerable, and because they're vulnerable in a particular way, that also dictates who will be able to exploit them. That tells you their constraints and their exploitability, their vulnerability tells you what groups are going to be targeting them. Because that's the other thing. We talked about this already before. The offender understands perfectly well the concept of intersectionality. They understand perfectly well who's going to get resources, who's going to get helped, who's vulnerable. They understand it perfectly well. We've been teaching them their whole lives who has value and who doesn't. So when an offender takes action, commits violence against a person, it's really them saying, yeah, I understand the values of this culture. I understand women don't matter. I understand immigrants don't matter. I understand the prostitutes can be raped and beaten. I understand that. That's okay, because nobody's going to help these people. The offender's violent crime is an editorial on what they believe we don't value.
And is a result of the impunity or the context where they operate.
That's right. So the context of impunity is pretty important here as well. When somebody can act without consequence, that's impunity. And most crimes occur in a context of tremendous impunity. So finally, let's talk about this whole violence. So back in the old days, and even recently, we were all taught that domestic violence exists inside this cycle, right? There's a cycle of violence. And explain the cycle of violence from as you were taught it as a psychologist.
Well, this is a very basic concept where basically they're saying that the aggressor and the victim has this cycle where there's a conflict that starts building, and then that conflict became like an aggression. That's the violence. That's right. And then they call it even the honeymoon phase. Yeah, they do. And they come back to the same point, and then the aggression start building. So the spiral of violence is the concept that psychologists using for trying to explain why victims keep in a cycle of violence.
That's right. And that is a very simple, two-dimensional view that you can only really entertain if you're looking at it from the outside. Because from your point of view, from the point of view of the outside observer, it is a cycle. Oh, it was terrible. Then she forgave him, and now they're starting over again. That's how it looks, right?
Yeah, because they say, oh, again. No, that's not again. Again is not the same. Right. This is getting worse.
Right. So what happens in the spiral is three-dimensional, and it isn't flat, it goes down like a drain. And what we mean by that is every single time an act of violence is committed and then forgiven, and there's a honeymoon phase and it starts over, it doesn't start over from the beginning. A new level of violence has now been normalized. And so the offender engages in ever increasing levels of violence.
And then one part of that violence became like a visit to the hospital of the victim.
Yeah.
And then the medical doctor or the police don't do a proper interview,
Right.
or they don't believe that the violence was enough to report. And that they tell the victim, well, it's not bad enough. You
Right.
can come back to your house. And that creates more momentum for the spiral, because now the aggressor will learn that the state will do nothing.
He's emboldened because of the impunity. And the other thing that happens is as this spiral goes down, it's not just that the victim is experiencing more violence. It's that these variables, society,
Yeah.
community, their
Goes
relationships,
through all.
they get stripped away because they're seeing them from the perspective of a flat, two-dimensional, oh man, you just keep forgiving him for the same stuff over and over again. We're tired of this. We're not going to help you because you don't deserve help, because you are allowing this to happen, because you don't escape
Yes.
it. This is an absolute violation of
Yeah.
human rights, because when somebody comes to the state asking for help, when they're in this spiral and the state doesn't help them, whether they're the police
Or
or
the forensic people are not understanding the rights.
forensic people not understanding their rights and not understanding the nature of the spiral, and the fact that as they go down the spiral, they're getting all their support systems stripped away. What's waiting at the bottom is a femicide.
Yes.
And we are pushing by our inaction, unwillingness to recognize, our apathy, our frustration with the victim, because we actually aren't trying to get to know them or their problems or even help them. They're learning that there's no hope for them. At some point they're going to give up, and at some point the offender is going to feel just totally fine with killing them. Yeah. If it gets to that point. But normally, I mean, not normal. There is no normal. I can just say this. I've seen cases where it gets bad enough that the victim gets out, and I've seen a lot of cases where it gets to the point of homicide, and they never see it. They always think that that's the only choice they have. All right. It's not like they're wanting to stay in it. It's that they're trapped inside of it, and there's no resources for them. There's no help for them. There's nothing but stigma. And it's because of the way, the reason the offender feels safe acting this way in terms of the violence in their relationships is an editorial on us. They understand that we're not going to intervene. They understand that the police are not going to intervene. They understand the state's not going to help. They understand the hospitals don't want to help. They understand that friends and family don't want to help. And they certainly know that forensic examiners do not have the language or motivation to try to describe or understand these spirals of violence as they go down. They're counting on our apathy and our lack of due diligence.
That's why we think forensic experts should be identified as human rights defenders.
Yep.
Because if you understand this perspective,
That's right.
you can at least document this so future scientists can do something, or maybe do something in court and do a very good report that can actually change the outcome of this spiral.
I was going to look at the Saltillo case, but I can't remember where I have the report. Yeah, well, here we go. This is it right here, right?
Yes.
All right. So,
That's Hilario.
oh, whoops, sorry, that's hilarious. Sorry, wrong one. We're in a lot of cases. Sorry about that. Is this it? No, this is it. All right, so this is a case. Forgive us, this is in Spanish. I have an English version somewhere, but it doesn't matter. This is a case that we worked on for almost 3 years, right?
Yes.
And I'll give you the long and short of it. It involves a woman named, her name was Liliana, and she had a daughter. And she experienced a failure, a spiral of violence multiple times in a very short period of time. And she was essentially arrested along with her boyfriend for murdering her daughter. Her daughter received a violent blow to the back of the head, wound up dying from the injury to the head about a day and a half later, right?
Yes.
And the reason why we got involved is this guy's name is Sergio Mitre. Sergio Mitre is a former New York Yankees. Sergio Mitre, former New York Yankees pitcher. There he is right here. This is more what he looks like. Actually, this is more what he looks like now. It's kind of all methed out. Anyway, so This guy has a long history of femicidal violence towards his ex-wife, a pre-femicidal violence towards his ex-wife, towards his other girlfriends. He actually attacked a girlfriend on a video camera, beating her up naked in a hallway and dragged her back in. And the security guard actually helped him put her back in the room. He got arrested for that, and he got charged with some lower crime, and then that got dismissed when he went and had therapy for 3 days or something, right?
Yeah, because he was a star player in the local team.
That's right. Because he was a celebrity, and because he had money and agency, and because he was an American, he had a little more agency, or a lot more agency, than the women that he's dating. So he met this girl. She tried to move in with him, but that really didn't happen. I'll just give you the quick timeline. She gets pregnant, and he does not like that. He does not want her to be pregnant. So what does he do? He goes and he makes her get the concoction, the pills for an abortion. Now, it's not that she's pregnant for a little bit of time. She's been concealing it. How long was she pregnant for? Like 2 months?
Almost 4 months.
Almost 4 months pregnant. All right. So that's almost halfway through, right? It's very, very far along. Very difficult for her to conceal. While she's going and getting this concoction, he winds up attacking the daughter, who's 2 years old, 3 years old?
2 years old.
2 years old. And she comes back to the daughter massively injured. Later on, she convinces him to take her to the hospital. While they're at the hospital, she winds up dying. The daughter winds up dying, and they wind up getting arrested for her murder. Instead of helping her, the Attorney General's office, they take her into custody, and they proceed to torture her. They put a plastic bag over her head. They put salsa inside of her eyes. They push her on the floor, and they kick her with high heels. The prosecutor's a female, by the way. Prosecutor's a female. Then the other thing that happens, and I think I got it out of order here, but the other thing that happens is she has the abortion, and she winds up flushing it down the toilet in the house that she's living in with Sergio. Then she goes to jail for the crime.
Yes.
She's not actually responsible for this crime. In fact, the reason she moved in with Sergio is because her father, who beat her mother so bad and strangled her so bad her mother can't speak correctly, her father physically beat her and physically threatened her and kicked her out of the house. Kicked her and her daughter out of the house. So we have violence from her father. We have violence from Sergio. We have violence from the Fiscalia. And then the psychologist goes in and does an assessment of her. And what does he say? The psychologist says, "Oh, well, I don't like her because she's being very disrespectful," right?
No, she was saying that the daughter one time had some kind of dirt in the face, so he was like, maybe it's a bad mother, because the 2-year-old older was not perfectly clean.
That's right. What's her name? Liliana. What doesn't matter. Doesn't matter. Let's go. So we wind up going and testifying in court. We testify, and what the great thing about this courthouse is, they had this cycle of violence things everywhere at the entrance and whatever, and right outside the courtroom. And so I get on the stand and I reference it. First thing that happened is our criminalist, Valeria Balthazar, she testifies about the physical evidence. She does a great job of laying out the timeline and all the physical evidence of the crime and how it points to Sergio and not to her. I come in and I talk about the victimology, the intersectionality, and the pathological failure of the state and the police to protect her. And I'm sitting there in court testifying right next to the prosecutors who tortured her. And so every time I get a chance, I just look over and I say, well, that's because you guys tortured her. You tortured her, you did this, you did that, you did this. And at every stage along the way, you failed her because she's a woman, because she's poor, because this guy's a baseball player and wealthy, and you identify with him, not with her. And you think this is about culturally, she let her child be killed by this guy, so somehow she's culpable, instead of understanding that she's in a spiral of violence.
Yeah, so basically, the violence she's living is the same. Is from the same system. One is maybe because the forensic psychologists don't know their work and they do these very stereotypical comments, but also because the friends of Sergio Mitre was seeing everything, but they didn't say nothing because they see this as natural, normal in their context. So basically, when we see victims, this is part of something bigger than just the aggressor.
And it also gives us the language to describe the vulnerability of the victim and their role inside that power structure, so that the the 3-judge panel in this case could understand. They took great notes. And at the end of the trial for her, not only did they acquit her and find that the state tortured her, agreeing with all of our findings, they let her out and they put him on trial for murder. And later that same year, he was convicted and went to jail for now 50 years. So we were able to, by using this approach, by using this methodology, we were able to get the court to vacate to acquit her outright, to identify the damages that the state had caused her and her reparations that she needs, and then to put the correct person on trial. This is almost never happened. So we're very pleased with this approach. We think it's one of the best ways to approach these kinds of cases and to explain violence. And we are going to continue to develop and adapt these theories so that we can give better tools to our students. And that's the reason we wrote this book, because in this book, that's all we're talking about, is these concepts related to what's the true dimension of violence, what's the true nature of victimology and intersectionality, what's context constraint theory, and how are offenders actually motivated, not inside their head, but as a context of their culture, their community, and their perceived role in society, their ideology and their identity.
And how you see those concepts apply to specific cases and reports.
All right. And that, as they say, is that. Hopefully that gave you something new to think about as we're proceeding. So the new concepts, of course, is in integrating the human rights perspective, understanding the intersectionality and context constraint theory, and accepting the spiral of violence. Any questions? Any questions? Happy to answer questions. Oh, well, right here. Great, here we go. Okay, put the questions in the chat box.
Thank you so much, sir, for briefly explaining the topic of forensic victimology and its traits and characteristics, and also highlighting and emphasizing on the investigating principles, and for introducing the context constraint theory and explaining the cycle of vulnerability and violence. Now we can begin with the questioning session. So I open the stage to the audience to put up their questions. Everyone, you can please put up your questions in the chat box, or if you can also put up a question on the YouTube live that we're having. Any questions? Or you can unmute yourself and ask questions.
Okay, sir, I'll begin. Actually, so when we're talking about victimization in the Indian context, that would be around 90% of females who are being victimized than men, because we have this. So I don't know how it is in the context in the US. So is it very different when we're talking about victimization? Is it always perceived as victims as women or females for that matter, whatever, or is it different in the context of the US?
I think it's super important not to phrase it that way. I think it's super important not to think in terms of what's more common and what's not. That's never the question. When you're doing a forensic analysis, you are looking at the case at hand. You can have an imbalance of power and the aggressor be a female and the victim be a male very easily in a domestic violence context. That is not a problem at all for this model. What you've got to refrain from doing is thinking that whatever the average is, that's what's going on here. That's the danger. That's the seductive nature of nomothetic and statistical approaches. It blinds us to what's happening in the case right in front of us. So the answer is women are more often the victim of violence than men. That is absolutely true. That's why they're a protected group. But can it be idiographically that there is a context where the male is the victim and the female is the aggressor? Absolutely.
Yeah, men has poverty, disabilities, mental disease. There's other variables that create someone who can be a victim. And can be exploited. Men can be exploited very easily by women who understand how to recognize or by other men. Yeah, exactly, by other men a lot. Hopefully that helps.
Thank you, sir. Thank you. Is there anyone else with questions? Dr. Shulbana.
Good morning, all of you.
Morning.
And it was such an enlightening speech and presentation from you, sir. Thank you so much. So I have a question. We all know that domestic violence is a global issue, widespread, but to accept it as a typical and accepted behavior and being the victim of spiral violence. I think when we talk about the government or legislation authorities, what they can do to address this issue when the society, especially I'm talking about our society, Indian society, where it sanctions indirectly, it sanctions this type of violence where the parents are, telling the girl or women to, compromise because divorce is a very big taboo in our society. So where the parents are, raising their, especially girl children, in a way, and they are telling them to compromise in the name of sanctity of marriage. So where the government and legislation authorities, forensic victimologists have a role to play here. In the society, the fabric of the very society is like this.
I totally agree that they do. We have our role always is to tell the truth. That's the first thing. But before we can tell the truth, we have to have the language and the tools to understand the truth.
Yeah.
And what our role as forensic victimologists or forensic criminologists or forensic psychologists or criminal psychologists is to make sure that we are using the most recent literature and have good tools to understand and explain the phenomenons that are occurring to the people who make decisions. That means our research has to be accessible. That means our ideas have to be accessible. That means our casework has to be done in such a way that we're teaching people as well about the phenomenon in general, as well as about the case in specific. Our role is to tell the truth to power it all and to document it. If you're not, one of the things I keep running into is profilers, victimologists, criminologists who don't write forensic reports. They'll come up with an opinion, they'll go testify in court, but they won't write a report down. If you haven't written a report, you're not doing science. Our job is to do good science that protects the rights of everybody involved and gives everyone and make sure by doing that we're ensuring access to justice. That means that we have to believe at the outset that everyone is entitled to access to justice, that there are no groups that we are, suppressing, that we're making invisible by our speech or by not talking about them. I'll tell you where I'm guilty of this all the time. I'm guilty of this all the time because when I'm talking about different groups that are vulnerable, I have to remind myself, because of my upbringing, because of my context, because of the context of my face and my color, my skin, and my privilege, I have to remind myself that there were indigenous peoples in the United States before we got there. And I have to remind myself that they still exist because they have been made invisible by policy and space in our country. Education that we get hides those people from us. So our responsibility is to learn the history of a space, to learn the nature of a culture, to learn the power dynamics and relationships, and then tell them truthfully in our reports. That's our role, so that these things can be used effectively by policymakers. In Africa,
Can't agree enough, sir. Thank you so much. Thank you, sir.
I'm trying. Major systemic. Sarah says, the traditional culture values normalize violence against women. Have you got and everybody values that marginalize women? I will tell you right now that anywhere there's religion, there is harm being inflicted. There is social control being exercised. Whether it's Christian, Muslim, doesn't matter. Most religion is about social control and negotiating sexual access to young girls by older men. That's what religion boils down to in a cultural sense. And that is almost always exploitative for the women that are involved. That's just one example. All right. The cultural values of the second cultural value is the notion that there are people who are better than other people, who are out.
Brent, sir, your voice is getting, we can't hear you. So we still can't hear you. I think you've, some, no, nada. No, sir, we cannot. We still can't hear you. So could you try maybe leaving the meeting and joining again? So we still can't hear you for some reason.
So can you try joining back?
So could you leave the exit the meeting and try rejoining again? So you're on mute, sir.
Okay, how about now? We're good?
Yeah, we can hear you
Nope.
now.
Perfect. Sorry about that. I don't know what it was. All right, so let me go to the questions over here.
About cultural values.
About cultural every culture has some form of violence that's being committed on its members to control the members that are in poverty and have less agency. So there's always some form of harm that's being committed by cultural values. That's the nature of culture, is to allow one group to rise and another group to be suppressed or exploited.
Yeah, and also the constant that the psychologist Martin Barreau was saying is that cultures, when you have dehumanization
Yep.
and exploitations as something normal in a system, you will create a lot of people who will treat each other through violent ways.
And what's interesting to me is no matter where I go in the world, whether I'm in Colombia or Guatemala or Mexico or the United States or South Korea or Scotland, wherever I work, I encounter the same thing. That country has a value system that says they're better, if not the best in the world, they're better than these other groups. There's always some inherent racism in almost every culture towards other countries' nationalities or cultures. So that's also harmful. Because why? Because those very people are often the people that come to that country to work.
Yeah.
Anytime
It's about class and work also.
about class and work and sort of putting immigrants in their place.
Exploitation.
Yeah, exploitation through correction, right? And low pay and slave wages. Other questions, please. Thanks, Sarah.
Yes, Dr. Swan.
Sir, good morning. First of all, I would like to congratulate you for such a wonderful presentation, sir. My simple question is that related to this Amber Heard and Johnny Depp trial. So what's your opinion? Like, because since there are many videos
What's the
and
question?
speculations, so as a forensic victimologist and other forensic criminologist, so what your opinion, sir? How we have to look as a
I'm not hearing
student
you.
of criminology? How we have to take and the why? Am I audible, sir?
No, I didn't hear your question.
So my question is that as a student of criminology, so how we have to take that trial and what we have to learn from that?
Well, that's a big question. I'll just say what I learned from it, which is that some of the experts that they had were just ridiculously bad. It was such a great lesson in how many forensic psychologists don't understand the basics of their profession, don't understand psychology, don't understand psychological assessments. Let me give you a fun fact that you probably don't know. Most of the forensic psychologists that testify in court do so in terms of establishing some sort of diagnosis from the DSM, right? That's completely inappropriate because the DSM says right in the front, the very first part of the Diagnostics and Statistics Manual, the 5th edition, says right up in front, plain language, do not, no place in a forensic psychologist don't read. They don't read, and they don't know that that's a limitation that's set upon it. Oh, shoot. Did we lose me? Uh-oh. Can you hear me okay? Hold on. Let me turn this off.
Yes, we can hear you. Yes, we can
Okay,
hear
good.
you, sir. Yes.
All right, so essentially, forensic psychologists don't read. They're dangerously undereducated, underinformed, and they're using the wrong tool in court. That was the first thing I learned. The second thing is that what we learned about was the impunity of people with privilege and what they perceive to be celebrity and agency when they're fabricating evidence. So much evidence was fabricated by Amber Heard, and she got caught every step along the way. And instead of admitting it, she just simply doubled down. So if you ever wanted sort of a master class in false testimony, this was a great example of that. There's another dimension, which is the Johnny Depp dimension. One of the things that Aurelio taught me was what the concept of the violence that the victim over time, they're exploited, they're hurt, they're damaged, they're injured. The violence accumulates, and then finally they explode back in ways like getting angry, or they push or they punch or whatever, and then that event is used to suggest that they're the aggressor. What do you call it? There's a phrase for that, right?
Yes, it's reactive violence, but I think in this case we just don't know. I think we need to understand that if there's a case, there's a specifically like this, a trial that we've seen on TV.
Yep.
That's not a trial. That's a publicity stunt.
It really is.
Whatever is happening right now is about money, and it's always about that.
Well, let me explain to you how the trial system works, just in case for people who don't really understand it. You're not seeing all the evidence. You're seeing what was collected and saved, what was admitted by what the defense attorneys and the other attorneys wanted to admit, and then after reviewing all that, what the judge allowed in. So we're seeing a very narrow trial, a very narrowly curated set of evidence packages that the court wants us to see. We're not seeing everything. In fact, most cases, if you imagine there's 100% of the evidence that exists, by the time you get to trial and it gets in front of a jury or a set of judges, they're looking at about 5 to 10% of the evidence. So it's really, without looking at the actual evidence in the case, it's hard to comment on what's true and what's not. We do know that Amber Heard lied like crazy, and that the forensic psychologists involved really didn't understand their role, their craft, or the limitations of the tools they were using. And that to me was the most distressing part, because violence, to hide harm, to hide what a victim is actually experiencing, to hide the humanity of people. It dehumanized. The clinical approach was really dehumanizing as far as I'm concerned. All right, other questions? Could you hold up the book and give us its title? Oh, sure, yeah, sure. This is, you can buy it on Amazon. It's Criminal Psychology, and it's by Turvey and Coronado. I'm Turvey, that's Coronado. And this one just came out like 2 months ago.
2 months ago.
This is the one that we worked on this inside the pandemic for 2 years to redevelop these ideas, to revisit victimology, to make sure that the tools that we had were based on the best literature that's available, incorporating intersectionality, incorporating context constraint theory, incorporating the spiral of violence, advancing ideas related to motivation or something.
Yes, Viola, ma'am.
Ask away. I'm ready.
Beulah ma'am, can you?
Okay, can you hear me now? Okay, yes. So I was wondering about new context to the routine activity.
She's got two things. Got two devices open there, Beulah.
Just turn off yours.
Yes. With the new routine activity theory and to the new cycle of violence theory, I was thinking of the learned helplessness. So maybe, what are your comments on that? Whether that would also have a new context? The learned helplessness. I can't hear.
Brent, sir, I think your audio is showing the same trouble again. No, we still can't hear you, sir. So could you please leave the meeting and rejoin again like you did last time?
Switch to Bruce Lee. I'll use this.
So we still can't hear you. Just
Okay, can you hear me now?
yes, sir. Yes, sir.
Perfect. All right. What's the question?
Can't hear. No.
Beulah ma'am, could you please again? Okay. So I think what ma'am was asking was how you view learned helplessness in psychology with
I didn't understand that question. I mean, I heard it, but I don't understand what you're asking.
Beulah
Can you
ma'am,
rephrase it?
can you elaborate?
Yeah, I don't understand the question. What I'll just say is it's the role of forensic examiners to develop tools to help them understand their cases. Sometimes you develop tools based on old models and old thinking, and sometimes the case itself forces you to develop new tools and new ideas and integrate new perspectives. It wasn't until I started working with Dr. Coronado about 8 years ago that I started incorporating a human rights perspective. I had already done a level of that in my work, but I was nowhere near where I could be. And so as we worked together, we got better at we've developed new tools and new approaches, borrowing from what's referred to approaching the problem of crime, victimology, profiling, motivation, from what's called a transdisciplinary perspective, where it's not the criminologist does one thing, the victimologist does another thing, and the psychologist does another, and you put it in one report. That's multidisciplinary. Transdisciplinary is when you sit down and you use multiple disciplines and the literature for multiple disciplines to develop new language and new tools to describe the problems that exist. Right? It's the transdisciplinary approach is extremely important, and it's how science is meant to advance.
Yeah, especially in the forensic context, because it's a case-based.
That's right. There are certain approaches that won't work on every case. It will be one tool will be good in one case, and another case will require a different tool. But that's when it comes down to the expertise. You have to master the literature. You have to know the tools that exist, and you have to understand what the limitations of those tools are on a case-by-case basis. And when you don't have the right tools and information to examine a case, you are required to reach outside of your discipline to other literature and integrate that into your own and come up with a new language for describing a problem or for understanding a problem. Because that's what we're trying to do ultimately. We're trying to understand the dimensions of violence and the relationships between the victim, the aggressor, the violence, their history, and their context. Other questions?
Okay, thank you, sir. Actually, correct me if I'm wrong with the understanding of constraint theory. So, basically, you stated that constraint theory is basically an individual's limitation, and that becomes
I'm not sure I understand your question.
No. I am going to. Is this correct when I say that constraint theory basically specifies that an individual's constraint or limitation can be removed is one that is right?
Well, what it is that each individual is constrained by their intersectionality, by their vulnerabilities. And those constraints, which amount to vulnerabilities, are what the offender is targeting. It's what the offender is exploiting.
The limitations.
The limitations of the person. You just use limitations.
Is this particularly limited to, it's very culturally based. Like, for example, in the Indian context, this word, you would say that the marginalized group, like have Dalits. So people from the Dalit group would be the ones who are affected by the constraint as victims, or would be perceived as victims. Or we talk about the American context, the African Americans more subjected as being victims according to the constraint theory. Is that right?
Well, it's not about who's more of a victim or not. It's about victimity is a legal state. It's about who suffered harm or loss in a given case, right? That's what a victim is. Now, before somebody becomes a victim, they exist as an individual with a context, with certain constraints, with certain vulnerabilities. And the people with more vulnerabilities, with more constraints on their context, those are the ones who are going to be targeted. Those are the ones who are going to be exploited. All right? So it's not about defining victim. Those are two separate questions. So whether or not someone suffered harm or loss is one question, and then specifically how that harm or loss is related to their intersectionality or their vulnerability is a function of is what constraint theory teaches us, or evidences to us. Right. So I would say if you want to learn more about these ideas, we have Forensic Victimology in its 3rd edition. It's about to come out, but you can buy 2nd edition. It's still good on Amazon, or you can get Criminal Psychology, the book that we just put up. That's where you can go there. We actually have a master's degree, which starts in February again, that on forensic criminology and criminal profiling that addresses all these issues. We also do individual programs of professional diplomas on forensic victimology, and I think we're going to do one on criminal psychology.
We're going to start
professional diplomatic criminal psychology, probably starting within the next 2 months.
Yes.
And that leads right into the master's. So yeah, we do have those things available for those people who are interested. The books are available for those people who are interested, and you can't stop seeing us on Facebook. We post a lot of stuff there. If you follow us on Facebook or Instagram or even TikTok, we have stuff there as well. Thank you for your lengthy presentation.
Okay, so that's a question.
Yeah, it's the cases of, as in the case of domestic violence, it's more about power and dominance and control. Yeah, I mean, it's for the individual, yes, but remember, crimes are not committed in a vacuum by individuals. Individuals commit the crimes, specifically in domestic violence context. that they think they can get away with. It's a function of necropolitics. Women are most likely to be the victims of domestic violence because of the way that we regard women in our cultures and our societies globally. Right? Details of the books here in the chat. Yes, I can. I'll just go. I'll make it very simple. I'll take you right to. Let's see here. Go to personal. We're going to go to Amazon. If you're very interested in this, you can go right to my Amazon profile, and it has all my books there. All right. Oh yeah, and also you can go if you're interested in. If you're interested in our programs, you can go to our website. There we go. So those are the two links you need if you want to proceed and want to learn more. Yep, right there, Sarah, right there. You can go to the Forensic Institute website if you want to register for that program, and make sure to email us. We haven't put the information up about it. It'll be up probably by the end of the weekend, right?
Yes.
So check on Monday. Any other questions? All right. Thank you so much for your time. We appreciate being invited. Thank you to our hosts, and I hope that we all stay in touch.
Thank you. Now we have Vice Chancellor here with us. We would give presidential address.
Perfect.
Hope you hang around with us.
Thank you.
Over to you.
Okay, thank you. Thank you, sir. So now I take honor in inviting Padma Shri Professor Dr. J.M. Vyas, sir, Vice Chancellor of NFSU, to give us the presidential address. He is the senior most forensic scientist of our country with 48 years of experience. Pioneer in establishing the world's first forensic science university at Gandhinagar, now a central university and institution of national importance. Vyas sir has completed his Master of Science, PhD, and LLB before he ventured into the services. And he served as the director of the Directorate of Forensic Science, Gujarat, from the state of 1993 until his retirement in 2009. He held the additional charge of the office until 2020. He was the Director General of the Gujarat Forensic Science University from February 2009 to 2020, which has been later renamed as National Forensic Science University and is now the Vice Chancellor.
He was awarded the President's Medal for his service in 1997. In 2004, he was awarded the Commendation Certificate as the Best Forensic Science Laboratory Director at the 15th All India Forensic Science Conference. He was also awarded the Lifetime Achievement Award in Forensic Chemistry by Amity University and AIIMS, New Delhi in 2008. He was awarded the Padma Shri by the Government of India in 2022 for his contribution in the field of forensic science and engineering. Under his guidance, National Forensic Sciences University, Gandhinagar, has signed many MOUs. Now, I welcome Sir to deliver an opening remark on the conference.
Thank you, and good morning, everyone. Professor Brent, Director of Forensic Criminology Institute, USA.
Sorry, I missed that. Could you say that again? I didn't quite hear it.
He's just addressing you.
Thank you. Sorry for asking me a question.
Dr. Beula, and Chair Professor of Criminology at the National Forensic Science University, India. The participants who are there from various parts of the country and the world, and dear friends. It is indeed a matter of pleasure for me to address all of you on this big occasion and inaugurate and offer my presidential speech. I'm very unfortunately I was late because I was asked to go to some other international conference which was on pharmacy. So I was the chief guest. I inaugurated that conference and straight away came here. So my apology for being late. And I'm really happy and congratulate Dr. Beula Segar. She really took initiative of projecting and promoting this very important area of victimology, because normally this field remains ignored, neglected, and mainly we focus on punishing the people who are involved in crime and criminal related activities. So the focus also is required to be drawn on the victims as to what we are doing for the victims. And victims are all kinds, and especially what we have seen, most of the victims are women, and then unfortunately no much attention is paid to the kind of crime the women victims have faced. So it's a very important thing, and this is how the promotion of victimology area is very much required. Now the question comes, how can forensic and victimology can go together? But forensic plays a very important pillar of criminal justice delivery system. So, and then criminal justice delivery system can play a role in two ways: identifying the perpetrator of crime and see that they are properly prosecuted and convicted, and also to take care of the rehabilitation of the victims. So one of the important area of victimology is rehabilitation. So how do you rehabilitate? Rehabilitation can be done in two manners. Rehabilitation, either providing them some financial support, they can be rehabilitated, but then the victims who have undergone trauma kind of thing after they have faced the crime, you see, for example, rape victims. So for them, rehabilitation in financial terms is not sufficient. You need to them do some kind of psychological counseling to this kind of victims, and so that mentally they are rehabilitated. One rehabilitation is physical, and the other rehabilitation is mental, psychological. So psychological rehabilitation is also equal, but so that they are able to lead their life in a normal way. So what we have done is to take care of this victimology aspects, because mainly there are doctors and nurses who take care of this kind of victims who get admitted in a hospital. So we have come out with a new program called forensic nursing. And this forensic nursing program, we train the nurses in such a manner that they are not capable enough to only collect various important evidences from the victim, but they are also have been trained by us as far as the psychological counseling is concerned. So they handle the psychological counseling of the victim when they are admitted in the hospitals. So it serves two purposes: a proper collection of all evidences which victim possesses, and then the psychological counseling of the victim so that the victim comes out of trauma. So this, I feel forensic nursing program is a more proper program in taking care of victimology aspects, because there you really focus on the problems the victims are facing and how to take care of them. And the other aspect is financially support them. Then also we need to train judges and create awareness in that only punishing accused is not sufficient. They should also come out with some kind of judgments where the victims are also rehabilitated physically, if not mentally, because mentally the people can take care of. So counseling has become a very important aspect. So this counseling need to be done using your psychological methods, where we have clinical psychologists, we have forensic psychologists, we have neuropsychologists, we have child psychologists, we have cyber psychologists. All these people together can play a major role in rehabilitation part, which is normally in the form of psychological rehabilitation. So in victimology, forensic plays a very important role. And then we rehabilitate and compensate them. So this is a very good area, and we need to focus it for the purpose of giving benefit to the victims, which, as I said initially, that which has remained ignored and neglected area. So I'm really happy that Dr. Mehbooba Sekar has taken up this victimology aspects in a big way in India. Probably we are the leaders as far as victimology is concerned in this country. And I am sure we are determined that we will try to see that this is promoted, and awareness amongst police, awareness amongst doctors who treat the patients, awareness amongst nurses, awareness amongst judges, awareness amongst prosecutors is created in this particular aspect, so that the victims are given proper justice. And that is the purpose of this victimology workshop we have conducted today, so that we can give some kind of awareness to the people, to the participants. And I'm sure the topics I have seen are very important, and even the nursing component is also added here. So there will be some experts talking on forensic nursing, there are experts talking on toxicology part, because victims have suffered a kind of a poisoning. It could be homicidal poisoning. So then this kind of victims are to be brought out from this poisoning effect by giving some antidote, and to see that they become normal after the treatment. So that also is very important. They are the victims of poisoning, victims of rape, victims of attempt to murder, victims of some other areas. So these are the victims of financial crime. So they lost money, etc. So all these varieties of crimes are to be taken into account, and accordingly we have to come out with methods as to how can we help victims. It's a very important thing. So I'm again thankful to all of you for giving me this opportunity to share my views on this. And again, my apology for being late and addressing this conference. Thank you. Thank you all.
Yes, Dr. Purvi, to welcome for the
Yeah.
say a few words about that.
Sure. So, as most of you are now quite well aware of, that we are organizing this World Society of Victimology Conference, a very prestigious event in the year 2024. So I, on behalf of our beloved Vice Chancellor and on behalf of the National Forensic Sciences University, welcome you all to visit a very unique campus, which is vibrant with a lot of activities in the forensic science and allied disciplines. We have some of the very exceptional Center of Excellence. One of the most important Center of Excellence, which is related to the victim support system, is the Center of Excellence in Forensic and Investigative Psychology, and Center of Excellence that we are now proposing on Happiness and Well-being, which is quite aligned with the whole purpose of the work of the victimologist. So I welcome on behalf of NFSU to visit the campus and be the part of this vibrant event in 2024. Thank you all.
Also, for your information, next week we are organizing a course on forensic victimology for the teachers in the area of criminology, victimology, and law. So the flyers have gone out. So hope all of you will be part of this 1-week certificate course on forensic victimology that will be hosted by the criminology school in the Gandhinagar campus. So thank you very much for being part of this, and hope to see you all here for the certificate course as well. Thank you.
Thank you, Professor Band, for your support. I'm really thankful.
Some
Thank you, sir. Thank you, ma'am. And I strongly believe that no one else could elaborate on the role of NFSU better than Vyas sir himself. So thank you so much, sir. With this, we've come to an end of the inaugural session of the conference. Everyone is requested to go for the lunch break and assemble back in front of your screens for the first technical session of the conference at 2 p.m. The chair and co-chairpersons and presenters are requested to be in front of your screens.
Hello, Radha ma'am, am I audible?
Yes, I am very much here online.
Yes, ma'am. Yes. Yeah.
I didn't put my video on. You want my video also to be put on?
Ma'am, yes, ma'am. Can you please turn on your camera?
Yes, I did.
Yes, ma'am. Now it's clearly visible.
Then deliberately I want to put up the camera. The reason is that bandwidth may become a problem. So if I am on camera and I am also talking, so
Yes, ma'am. That you can do, ma'am. Yes, ma'am.
I'll once I get introduced to the audience, then probably I'll switch off my video so that it saves a lot of bandwidth.
Yes, ma'am, I understand, ma'am. No problem.
Good afternoon, Ms. Sharda. Good to see you.
Good afternoon.
And thank you very much for accepting our invitation. And
it's my
being
pleasure,
with us.
and it's a great platform, I feel, so that I can share whatever little knowledge I have. I can share, and in the process, get myself upgraded with this. This being
I
a
saw you in the morning session as well. Thank you for attending. Did you hear the Vice Chancellor speak?
Unfortunately, I mean, most of the time in the morning there was no power, from my side.
Okay. I hope we don't have any of those glitches now.
Now, I hope positively there shouldn't be any problem.
And it'll be nice to have your camera on if you can.
Yeah, that's
But
what
if
I
you
was
can't,
just trying
it's okay.
to
Try
discuss
to do
with,
it.
Shada ma'am, can you please share your presentation so that we will check it?
I have already shared it with you. I have already shared it with you.
No, online, ma'am. Here only. Here also.
No,
I did it, but anyway, I'll try from my side in case if any problem is there. I have
Yes,
already shared the PowerPoint with you.
Yes, ma'am. Yes.
Okay.
Please
Should
share
we
it.
start up?
Yes, 1 second, ma'am.
Kirtika, take over and start exactly at 2.
Yes, ma'am.
Yeah.
More options. More problem. అది ఇక్కడికి వెళ్ళాలి. Stop sharing.
Yes, ma'am, your presentation is visible.
And it's perfect.
But you want me to put it on the screen mode?
Sorry, ma'am?
Slide mode.
Yes, ma'am, put it on the slide mode.
Is it now visible in a bigger size?
No, ma'am, not right now.
Just wait for a second. If it is full screen, then it will be good, I have put it in the full screen mode. Is it visible now? Full screen mode?
No, ma'am, it's not visible in the full screen mode.
I have put it on the full screen mode only.
Ma'am, maybe because of the internet connectivity, it's taking longer. I'll let you know if it doesn't show in 1 or 2 minutes. Ma'am, can you press the F5 button?
S5 button.
F5.
Wait for a second.
Sure, ma'am.
S5. Okay. Screen share slide show. Yeah, now tell me, is it visible on the full screen?
No, ma'am.
No?
No, ma'am.
Stop sharing. Stop sharing.
Ma'am? Sharda ma'am? Ma'am, am I audible to you?
Send her a message.
Sure, ma'am.
Stop. Is the mic on now? Am I audible?
Yes, ma'am, you're audible. Ma'am, we're about to start with it, and we can see your presentation.
Presentation. I have started sharing. I think
Yes,
is
ma'am.
it not visible?
Yes, ma'am, it's visible.
I am trying to put it. I am trying to put it full screen, but somehow I am not getting the full screen. But anyway,
Ma'am,
is
it's
it
okay, ma'am,
visible,
it's okay.
readable?
Yes, ma'am, it's readable. It's okay. It's visible.
It's
Ma'am, we're about
visible. I
to
mean, let
start.
us go ahead.
Yes, ma'am, we're about to proceed with the session. Ma'am, can you stop sharing for a while your screen?
1 second. I'll do that. I have stopped sharing.
All right, ma'am. Thank you, ma'am. Hello, everyone. Welcome back. I am Kritika Diora, Research Associate at LNJN, NICFS, NFSU Delhi campus. I hope you've all had a very pleasant lunch. After the successful inaugural session of India's first international conference on forensic victimology, now we are about to begin with the first technical session of the conference. The topic of the session is Challenges in the Forensic Victimology. We have Best Paper Presentation Award in the following 3 categories: Professional category, Scholar category, and Student categories. Proceeding further, the speaker of the session is Ms. Sharda Avdanam. She is retired director of Andhra Pradesh Forensic Sciences Laboratory. She has also served as deputy director of Andhra Pradesh Police Academy. She set up the first DNA lab at Andhra Pradesh Forensic Laboratory. She has published her research work widely in national and international journals. She has also been awarded Directorate of Forensic Science Merit Award for overall excellence and good service rendered in forensic field by Ministry of Home Affairs. Now I request ma'am to proceed with her session. Ma'am, please share your PPT.
Yes, I'll do that. Just give me a second. Is the screen visible now? I have already shared the screen. Hello?
Yes, ma'am, your screen is visible.
Good afternoon, everybody, and I thank profusely the organizers who have given me this opportunity to interact with so many people online. And it is always a little difficult task, I feel, because of my experience with the National Police Academy probationers. So it will be a little tough job to engage people, that too online, and a subject called, victimology. But anyway, I'll try to do it the best way I can do it. And now, when we say challenges in the victimology, before I open up the PowerPoint, let me also just give you a brief that, why this victimology, we consider it as, an area with full of challenges. Now, it is the perception, how we see it. Are we trying to see even small little issues, bloating it up to the level of a challenge, or is it a real challenge that we need to understand in the first place? The reason is that we have welfare state where the state assumes from birth to death the responsibility of its subjects. Subjects, I mean the citizens here. In the criminal justice system, a crime is an offense or a public wrong against the society. So the state prosecutes the criminal on behalf of the society. The state functions, unfortunate or fortunate, are divided into legislative, executive, and then the judiciary. But the legislative has taken over lawmaking based on the constitution and of course the fundamental rights. The rights of the victim are lost sight of, unfortunately. As IPC, CRPC, Evidence Act made by the legislators take cognizance of the rights of the accused only, unfortunate. This realization dawned on them at the time of 1975 emergency, and also, of course, we know that 1984 Sikh riots. Everybody realized that there was no law in support of the victim's right. Executive was busy supporting the powerful public representatives and, of course, not the victim. So it fell to the judiciary to point out the lapses. And it is always Justice Krishna Iyer, who is a luminary, legal luminary, who he always tries to stand at the front. And he pointed out that the victim reparation is the vanishing point of the criminal law, rightly pointed out. Now, judiciary could only advise the legislature to pass on a law, but can't do it on its own. And 1985 riots gave birth to a large number of legislations. It was immediately followed by 1985, the king of Magna Carta for the victims' rights, namely the UN Declaration of Basic Principles of Justice for Victims of Crime, has seen its light. Now, victim has been at the receiving end throughout the criminal justice journey, and at each stage of criminal justice processing, it is robbed of its rights afresh and leading to re-victimization at each stage. And the UN Declaration has given rise to victim jurisdiction, victim jurisprudence, or compensatory jurisprudence, and in India and also abroad. The rights of the victims are codified in UN Declaration. A sizable proportion of the compensatory provisions have been enacted in CRPC, as well as judicial pronouncements. Now, the challenge is to bring in victim rights outreach or victims' right sensitization in the executive and lower judiciary. This is the order of the day. Now, as I progress through this session, now I try to focus my session into the UN Declaration parameters. Then, of course, lot of case laws, more than half a dozen case laws I try to project so that how these victims' rights have been evolved, and then what is the current status in India, and then what are all the other agencies which promote and which try to assert the victims' rights is what is going to be discussed during this half an hour or 40 minutes duration. Now, is my screen visible right now? I have already shared.
Yes, ma'am. Yes, ma'am. It is visible, ma'am.
Hello?
The screen closed, ma'am. Now it's not visible. You are audible, ma'am? Yes, ma'am. Now you are visible to us.
Is the screen visible and am I audible?
You are audible and clearly visible, ma'am, but the screen is not there. The screen is not there.
Mr. Hitesh?
Yes, ma'am. Am I audible, ma'am?
Is my screen visible? I try to share the screen, and also, am I audible?
You are audible, ma'am, clearly audible, and we will wait for the.
How about the screen? How about the screen?
The screen is not there, ma'am, still. We are waiting for that.
How about the screen? I have already shared the screen.
Okay. Let it come.
Is first slide visible on the screen?
Let it come, ma'am. Let it come.
Now, the first slide speaks about the rights of the victims. Though we have amended the Criminal Procedure Code in 2013, that's not sufficient because it alone cannot address all the rights of the victim. And of course, penal provisions in IPC also talk about rights of victim. But then what is wanting and what is missing is a full-fledged code which talks exclusively about the victim rights is what is the order of the day, which is completely wanting and then which has to take its place. Now, UN declaration is like a Magna Carta for victims' rights. As far as victims' rights are concerned, it is the Magna Carta, I can say. And then this gives the basic principles of justice for victims of crime, of abuse of power also. Victims of crime, and then also for the, it also covers the abuse of power. And if you see the definition as laid down under the UN declaration, it has got an inclusive kind of a definition. That means victim includes not only the individuals, but then we can say it's a social construct where it is the harm that has been suffered, and harm includes not only the physical harm, but it, as I said, is an inclusive kind of a definition which takes care of mental injury, emotional suffering, economic loss, and of course, impairment of their fundamental rights through the acts or omission, and which are construed as violation in criminal law. And then member states, including those laws prescribing criminal abuse of power. So this includes both abuse of power also. So it is an inclusive kind of a definition, and a wider definition also for the victim is envisaged in the declaration. And it also goes a step beyond in that, regardless of the perpetrator is identified. Normally, in any criminal proceedings, as we all know, it ends in identifying the perpetrator and penalizing him, prosecuting him, convicting him. And then victim always, as we know, takes a second seat, or it is relegated to a secondary position. Now, UN Declaration of Basic Principles of Justice for Victims very categorically and very clearly emphasizes that irrespective or regardless of whether the perpetrator is identified or apprehended or prosecuted or convicted, regardless of all this, and also regardless of the familiar relationship between the perpetrator and the victim, the term victim also includes, where appropriate, immediate family, dependents, and then the direct victim and persons who suffered harm in intervening. Somebody tries to help in between, and then in the process, they also get distressed, and then they also become victimized. So an inclusive kind of a definition is given in UN declaration, which includes all these categories of people, whosoever come and count are players in the crime. The provision contained herein shall be applicable to all. That means there is no race, color, caste, creed, sex, irrespective of these parameters, nationality and political and other opinions or cultural beliefs or practices, property, birth or family status, ethnic or social origin and disability. So what it says is, irrespective of this parameter, criminal is, after all, a criminal who suffers harm in the hands of the accused. Now, next comes the access to justice and then fair treatment. Now, when I say fair treatment, fairness has to appear not only in the trial, but during the investigation in the hands of the police or the law enforcement agencies, as and when the victim approaches the police for lodging a complaint, or the complainant goes and lodges a complaint, the victimization starts from that point of view. So access to justice and fair treatment, including the fair investigation, also is one of the key parameters that have been discussed under UN declaration. So victims should be treated with compassion. So patient hearing is half healing. So whenever a victim approaches the police station, a patient hearing is what is expected. So we do understand a lot of issues about gender sensitivity, and by and large, the system has understood the concept, and it has to now extend to the victim. Now, victim sensitization is one that we need to focus upon. Now, access to the mechanism of justice, prompt redress as provided by the national legislation for the harm that they have suffered in the hands of the accused. Judicial and administrative mechanisms should also be established, and they should be in place to obtain immediate redress through formal and informal. Though we have a very organized formal set of procedures in the form of judiciary, but then what is lacking is in its informal nature, it is almost wanting. So what this particular declaration emphasizes is we need to focus upon both the formal and informal procedures that are there. Informal, I mean here, arbitration, mediation, and then conciliation are the alternative methods of justice that is more prevalent nowadays. Now, we need to exploit this kind of informal procedures also, because we know that judiciary is overburdened with a lot of cases, and they are strongly recommending that whenever such challenges in victimology are faced, they should also explore the informal procedures like adopting the arbitration or alternative methods of jurisdiction. The restitution is another very important aspect when we talk of victimology. The offenders or third parties responsible for their behavior should, where appropriate, make their fair restitution to victims. Not only victims, their families, their dependents. And such a restitution should include return of property. Whenever there is a damage to property, it is but natural that they will be restored. That is return of property or payment for the harm or loss suffered. And then whenever there is some expenditure that has been incurred towards the medical expenditure, that needs to be reimbursed. And then provision of service and restoration of rights. So this is about restitution. And then government should review their practices and regulations, and then law to consider restitution as an available sentencing option. Sentencing option should not always be either fine or imprisonment, or as an alternative to these things. Restitution should also form a part of sentencing options whenever we are going in for criminal trial, in addition to the criminal sanctions. And then in case of substantial harm to the environment, of course, environmental law is very, very powerful. And then thanks to MC Mehta, who has a great promoter of pill and all, and he has taken the environmental science to such a height that polluter pays is the concept. And accordingly, a lot of cases we have seen where restoration of environment has taken place, and then replacement of community facilities, reimbursement of the expenses of relocation, whenever such harm results in the dislocation of the community. Now, a great amount of work has been done by MC Mehta, and then he's instrumental, of course, the proactive and judicial activism of the Justice Krishna Iyer also has taken this so forward that now almost we have laid down law for that, and then a lot of case laws also we find whenever we talk of environmental pollution. Now, where public officials or other agents acting as officials or quasi-official capacity have violated the national criminal law, then what should be the procedure? The victim should receive restitution from the state, naturally, because there is no criminal individual. So it is the public official, and public officials act in the on behalf of the government. So whenever there is any wrong, public wrong that is being done by public official, naturally the restitution has to be from the state only. Whose officials or agents were responsible for the harm inflicted? In case where the government under whose authority the Victimization Act or omission occurred is no longer in existence, the state or the government successor is the title should provide the restitution to the victim. So this is with regard to the restitution. Then comes the compensation. Now, compensation is also equally important now, because most of the time the criminal justice system focuses on the rights of the accused, how best we can protect the rights, how to make him aware of his rights, and then what do's are there, what don'ts are there. I mean, we always try to, I can say that it is accused-centric. Now, when we talk of victim, the compensation is the best part of understanding the victimization. When compensation is not fully available from the offender, because most of the time offenders economic status, if you see, they are either poor or not able to hire their own lawyer. So the reason is that compensation, whenever you want to pay, most of the time offender is not in a position, economic position, to pay the compensation. So in such cases, because it's a public wrong, now it is the onus of the state to take over, and it should be the endeavor of the state to provide the financial compensation to the victims who have sustained significant bodily injury. Whenever we talk of bodily injuries, if there is a substantial significance towards the bodily injury or impairment of physical and mental health as a result of serious crimes, and not only the victims, as the definition is a little wider, the family in particular, the dependents, because the victim is supposed dead and gone. Now, suppose she is the bread earner, and so it is the dependents that you need to think about, and then the dependents need to be compensated for whatever physical or mental incapacity that they receive as a result of such victimization. Now, the establishment, strengthening, and expansion of national funds for compensation to victims, very, very important aspect. Now, we know that in case of narcotic drugs and psychotropic substance, we have a provision for national fund, and whatever funds and whatever reformatory measures that the state has to take towards the victims of drug abuse. We have an enactment. In the enactment itself, there is a provision for creating a national fund. So similar lines, the UN declaration also promotes that there should be a fund called a national fund for compensation to victims, so that the funds can get accrued into the national fund, and from that fund we can pay the compensation. Where appropriate, other funds may also be established for this purpose, including in those cases where the state of which the victim is a national is not in a position to compensate the victim for the harm. Now, we have done with compensation, restitution also we have covered. Now comes the assistance. Now, victims should receive the necessary material, that is medical help, psychological help, social help, or assistance through governmental, voluntary, community-based, and indigenous. The problem is, though there are many institutions which exist to come forward and assist, but only because of the awareness. There is lack of awareness on the part of the victim. And it is mandatory, the UN declaration makes it mandatory that whenever such agencies, service providers are there, it is mandatory on the part of the government or the judiciary to make aware that these kind of service providers are there, and then the victim should make use of that service providers by way of assistance, not only medical, psychological, and social assistance, because the trauma after the post event is one thing which they have to manage meticulously. Otherwise, am I audible?
Okay.
Am I audible?
Yes, ma'am, you are audible.
So the police, justice, health, these are all the social services, and other personal concerns should receive training. As I said, the awareness is one thing, because most of the victims are not aware of the different services that are being provided to her. And not only that, the insensitivity on the part of the players of the criminal justice system, the stakeholders, namely the police, the
We are very sorry, we lost the connection with ma'am. She'll be here in a short moment of time.
Please stay on.
Please be connected.
Yes.
Ma'am, you're on mute.
Yes? Am I audible now?
Yes, ma'am.
The forensic aspects, if one has to discuss upon. Now, crimes like rape and then the crimes against the children, where they happen in isolation. There is no eyewitnesses for that. And the only evidence that is available for us to prosecute is the scientific evidences. But unfortunate that most of the times the victims do not report the crimes immediately, maybe because of the social stigma that is attached to the crime, or maybe that it it is the family pressure that they don't report out of shame and out of humility. These cases are not reported in time. Now, the result is because the evidences are mostly biological in nature and they will not long last with the passage of time. So whenever the victim of crime is not taken to the hospital for medical examination immediately, what will happen with the passage of time, with cleansing and with bath and all, the vital evidences that are very, very important for the prosecuting the case are being lost. And because of the unawareness on the part of the victim as well as the family members, they don't report also. And even in cases where it has been reported, it is at the police station that these details are not taken properly. In the FIR also, not very many ingredients of the crime are being taken. The result is that the victim, because it undergoes a lot of trauma in the process, they'll also forget, because memory gets fragmented because of the anxiety, because of the trauma that gets generated out of the crime. These finer details of the crime are not being properly described in the FIR. The result is that if the ingredients are not properly there, then it will be difficult for the prosecutors or for the law enforcement agencies to incorporate these things. Now, when it comes to the question of collecting the evidences, now we have seen in past also many cases where out of ignorance, the medical doctor who is conducting the examination of the victim, and though we say female medical officer in case of victims, not very many states or not very many hospitals have the provision of an exclusive female medical doctor. The result is that invariably the male medical officer has to examine even the victim. So there is a lot of humiliation attached there, and then the examination proper is also not being done. And where there is a legal provision that it has to be under videography coverage, so not very many cases we have seen that this particular aspect is not being covered. So when it comes to trial, this will also become a major point. Why, though it is a case very sensitive in nature, why it is not been why it is not been done when it is so mandatory, when the law mandates it that it should be videographed, why it is not being done. And most of the time also the medical legal reports, especially in case of rape victims, though it has been done by a team of doctors, it is so unfortunate the report doesn't reflect this. Only the chief medical officer or the officer who is in charge of the entire team will only sign, whereas the remaining two people who are a part of the team, they fail to sign. And this becomes a very, very important for the cross-examination, because in the cross-examination during trial, it is the contradiction that that is the trick. The most of the time, the cross-examination defense lawyer will try to focus upon. So these small little things in the examination or the generation of the report matters. Now, it is again a delay after the examination also, in case if the victim is dead and gone, where rape and murder case. So most of the times, the material objects that are being collected by the medical officers are not sent to the laboratory in time. The lab receives these evidences in the form of vaginal swabs, vaginal slides and all, and the pubic hair, and then the nail clippings. Whenever there is a scuffle that ensues between the victim and the accused, lot of material gets exchanged, especially in the nails of the victim and vice versa, also in the nail clippings of the accused. So most of the doctors conducting these tests either fail to collect these or will adopt such erroneous methods, so that even if they take it, it will be of no use when it reaches the forensic science laboratory. Now, the delay also adds to the disappearance of the evidences. By the time these evidences reach the FSL, most of the time we see that the materials are so deteriorated that even if the FSL has got the best of the equipment or the gadgets, they'll not be in a position to render any help. And then all the examination, all analysis on these already deteriorated exhibits will not yield any fruitful results. So the lab will be in a disadvantageous position, because by the time they receive these evidences, the whatever harm that has to happen to them, whatever environmental insults that the material objects are supposed to be meted with, these harm will happen, and ultimately they will be rendered useless. So and unfortunately, whatever report that gets generated, we may have to be contended with the negative reports. Now, judiciary also will come heavily, saying that when evidences reach you, why can't you design some tests where you can still work on these exhibits, so-called deteriorated, and then still can generate reports. So this way, even the judiciary also comes very heavily. And in most of the rural scenarios, if you take, of course, the urban setup is different. We have at least the wherewithal, we have the hospitals, and then there is awareness. But then when it comes to rural scenarios, because of the ignorance on the part of the victim, and also ignorance mostly on the civil assistant surgeon, because in the rural scenario, you do not have a forensic medicine doctor exclusively for conducting the medico-legal examinations. So result is, even the civil assistant surgeons, because it's also part of their curriculum to treat medico-legal cases, so they will come forward, and then they are not so learned. And the preservative that they are supposed to use, especially when you are referring the exhibits to DNA profiling and all, they don't have the wherewithal. And neither they bother to collect these evidences, the preservatives, at least from the nearby forensic science laboratory. So whatever preservative normally used for any blood tests are being used. Result is that the other routine preservatives which are used for blood testing and all are not to be used for DNA profiling, because DNA profiling is being a very conclusive test. So everybody should aim at sending the exhibits to DNA section. But then the problem is, because the civil assistant surgeons are not aware that there is a special preservative that needs to be added, and then the FTA cards and all. So because of the non-availability of these things, so they practice whatever is the routine practice of sending the exhibits in citric acid or the fluoride. They will try to preserve these exhibits in that preservative and then try to send it across to the lab. But the result is, most of the preservatives, common preservatives that we try to use for blood preservation are not very suitable. And not only that, they also interfere with the examination of DNA profiling. So, and in case the rape victim is dead and gone, rape and murder cases, so they try to preserve the viscera in the formaldehyde. And we know that formaldehyde, being a dehydrating agent, if somebody is preserving the exhibits in that preservative, it will not render any kind of it not only interferes with the DNA profiling, and it also blocks the entire process. So these minimum precautions, because there is no awareness or training programs for the civil assistant surgeons. Mostly it is the forensic medicine doctor. Probably he may be knowing these procedures of how to preserve the exhibits and then how to properly handle these exhibits. But when it comes to rural scenario, as I have already explained, the civil assistant surgeon most of the time do the job of a forensic medicine doctor. Result is that they do not understand the proper or right kind of a preservative, and then whatever preservative that is readily available, they to preserve they'll preserve the exhibits in that preservative, making the entire exhibit useless by the time it reaches the laboratory. Now, in the laboratory also, because of the workload and because of backlogs, by the time a sensational case comes to the laboratory, we are not able to give the required focus on it, and we are not able to open the case in the appropriate time, and result is that it further gets deteriorated. The material objects that are received get further deteriorated, and by the time the turn of that case comes to examination, then it further gets deteriorated, and then whatever test that we try to do, either the qualified or the quality DNA will not be available. And even if you want to do further PCR also, if enough quantity of DNA is not there, so any other method will not be of any use. And when it comes to preserving the cloth items or the garments worn by the victim at the time of the incident, most of the time, even the private hospitals where they are not very much aware of the medical legal cases, either they collect it and then put it in a dustbin, or they will mishandle it so roughly that even if stains are there, they will be contaminated, cross-contaminated, and then result is, again, by the time they reach the lab, they will be, the sending of the exhibits will become futile. And on the part of the investigating officer also, the handling procedures, there are a number of standing operating procedures that are in vogue, but only thing is the sensitivity on the part of the investigating officer, that is completely wanting. So with the result, if there is a wrong handling, there is a scope for cross-contamination, or there is a scope of development of lot of fungus and then bacteria, making the entire exhibit useless by the time it reaches the forensic science laboratory. Now, again, the staff crunch and all are, problems at the lab level, and then the procurement of the materials, because most of the time, the difficulty that the labs are facing is that the chemicals are not indigenous. They need to be got from other countries, and then the stock of the DNA kits will also be a problem. And whenever, of course, the Nirbhaya Fund all are coming to a great extent, great help in that most of the labs, they are exclusively going for cases which require attention, like POXO cases, whenever they are reported, because there is a mandate and the law stipulates that the entire investigation has to be done within a stipulated time. So to tackle exclusively these type of cases, we have labs established, and then they exclusively indulge in handling such cases only. Now, the new technologies, new gen kind of technologies that are coming, where even the minimum quantity of the DNA, if it is available, we can still do the analysis and all, because these equipment are very costly, and a lot of budgeting problem will also be there in the lab. So not very many labs can afford to buy these kind of gadgets. Result is that they need to invariably depend on some other central agency, like in Hyderabad we have CDFD. So most of the cases where states cannot afford that kind of equipment are mostly being referred to the CDFD. And CDFD also, earlier they used to do these cases on a free basis, but then since the equipment and since the chemicals that are the consumables that are used in these examinations are so costly that they cannot afford to do everything free of cost. So a nominal kind of a fee is also levied on different states whosoever refers such cases to the laboratory. And the report is also generated within no time, and then they are helping the laboratories in not only in establishing DNA units also, and wherever some professional expertise is required, they are also conducting some training programs, and then they are also giving a roadmap for labs who wish to establish a DNA unit, because most of the time DNA is the conclusive thing for any identification. So whenever the accused need to be identified on conclusive basis by comparing the accused sample vis-a-vis the questioned samples, then establish the identity. In such cases, the DNA profiling is the best conclusive test that is available. But the only problem is because it is associated with some cost and all, not very many labs can afford it. But then days are not very far that most of the labs, because of the Nirbhaya fund and all, they are able to come up with the establishment of DNA units, and then they are also able to procure. Because another problem from the government FSLC is that these procurement, especially the chemicals and then the gadgets, need to be gem empaneled. Now, gem empaneling is also, a lot of issues are there associated with that, because most of the vendors, they are not gem empaneled. And the government mandates that we need to buy everything through gem. And since most of the vendors, either they are proprietary in nature or they don't wish to empanel themselves under the gem, result is that we have to depend only on the sole vendor and then at least produce a certificate that he is the only vendor available. So hence we have procured these items from them. And the exhibits, when we talk of the wearing apparel of the accused or the victims, they need to be dried properly. They need to be handled properly by the enforcement agency. So unfortunate that, am I audible?
Yes, ma'am, we can hear you. Yes, we can hear you.
Ma'am, you're on mute. I think we lost the connection with ma'am. We'll wait for ma'am to join again. Till then, if anyone... Yes, ma'am.
Just to wind it off, I have to say that there are different stakeholders, and only when there is an integrated and an approach, an understanding between the different stakeholders of the criminal justice system, the cases, especially where the victim is a rape victim, then the only evidence I say is the scientific evidence, because there will not be any witnesses, there will not be any eyewitness for that. So all precaution has to be taken from the law enforcement point of view, and also avoiding delays in the lab, and then trying to analyze the material objects in time and trying to create a report which is timely report, and then submitting the findings to the lab. And not only this, when it comes to deposing the evidence in the court of law also, there are so many lapses that since the forensic scientist is never exposed to the court demeanor and all, so whatever experiences that he has got, he's never been shared to their subordinates, and then their experience in the court are very, very, not very encouraging, I should say. And there should also be some kind of a training to these forensic scientists also, how to depose the evidence so that victim gets her due rights and all. And when it comes to trial also, there should be fair trial, and the victim's rights should be clearly be emphasized. And only when there is an understanding between the stakeholders in a proper perspective, then victims' rights will be, of no use, is my opinion at the end. That's all I wanted to share.
Thank you so much, ma'am, for giving an insightful talk on the challenges in forensic victimology and emphasizing on the role of formal and informal mechanism in justice delivery system with regard to victim and victimization, and for pointing out the challenges in the examination of cases and the need for awareness program to preserve the evidences without it getting contaminated. so that better forensic evidences could be presented. Now I open the stage for question answering sessions. Before that, I would like to introduce the chair and co-chair. This session will be chaired by Dr. Krishna Kumar Mishra, Assistant Professor, School of Forensic Psychology, NFSU Gandhinagar Campus, Gujarat, and co-chaired by Dr. Vijo Vincent, Assistant Professor, Criminology, School of Forensic Psychology, NFSU Gandhinagar, Gujarat Campus. Over to you, sir.
Okay.
Very good. Aren't we taking some questions?
Yes, ma'am. This is a
Sharda,
question
ma'am.
answering session. So, sir will
Yes.
be proceeding with the questions. Sir will be asking the students to come up with the questions.
Okay. So, are we going to allow a student to have questions, or should I start the presentations?
Sorry, Dr. Mishra, these are questions for Dr. Sharda. I think after that, we'll start with the students.
Okay, ma'am. Thank you, ma'am. Thank you. Please, students, you can ask questions.
Students and other participants.
If there are any questions with regard to the presentation that ma'am just presented, please put it in the chat box. Yes, ma'am.
Thank you, Dr. Shraddha, for your presentation. I was wondering if you could give us some tips on what areas we should focus on when we are training the forensic scientists. What areas need to be covered when we try to train them and prepare them for the deposition or the examination of samples and things like that. Thank you.
Ma'am, my experience with the court is that most of the time, the forensic scientists, either in the curriculum or as a part of training, they were never given this code demeanor, how to behave, how to depose. They are wonderful people as far as the analysis is concerned. Whatever happens within the four walls, they are experts. But then when it comes to deposing what they have done, what analysis they have done. So most of the time, as a part of cross-examination, it is the defense lawyer who tries to contradict, and then who tries to discredit the expert. So result is, because they are never
Ma'am, you are on mute. Sharda, ma'am? Ma'am, your voice is not audible. You're on mute.
Now?
Yes, ma'am, we can hear you.
What I'm trying to say is, ma'am, now the experiences of the forensic scientists, when they come and depose, they depose their evidences in the court, it is the cross-examination they are afraid of, because it is the analysis is their forte, and then they know how to analyze. They are masters of the SOPs and all. But when it comes to the question of, after all our endeavor is to present our evidence in the court of law, before the court of law. If that particular aspect we are weak, then whatever analysis that we have done, whatever experiments that we have done, it will be a futile effort when you are not able to explain the outcome of your result. And then most of the time, the myth that is associated with the forensic scientists is that my report is self-explanatory. Once I give the report, that itself is a piece of evidence, is what they presume. But court wants beyond that. They want their report to be explained, because sometimes the report contains a lot of jargon. Difficulty in understanding the jargon is the main thing. So when the trier of the fact doesn't understand what exactly is a particular word, what does it mean, then he'll not be in a better position to give the verdict. So it so happens in the court that before going for deposition, I request, even in the curriculum, I am yet to see in any of the curriculum that this kind of court management, how to depose your evidence at the end of the day, is completely wanting. And I request all the institutions who are taking this forward to incorporate a chapter or a paper or one session on this, so that they exactly know what they have to explain in precision, And not only, I mean, they can't expect us to give us a very elaborate report. Report has to be very precise. It has to be crisp. And if I start giving the kind of experiments that I do, a list of them, that itself will run into volumes. I'll not be able to explain the report proper. So what I feel is there should be some kind of a court management procedure that has to be there as a part of curriculum. And only then that will help, because they will be trained in that aspect, how to depose, what kind of analysis report they have to explain, and then how they can avoid the jargon and all. So this kind of training is completely wanting, and I feel that all institutions to take this very seriously and then incorporate or put one as a curriculum and then try to train both the inductees as well as people who are in service.
Thank you. Thank you very much for your very pointed response. And if I hear you right, we could also say the other side of this is to include forensic science as a subject for the lawyers as well, the law curriculum as well, because like what you were saying, they are not familiar with it. Correct. Thank you. Thank you very much. That was a very important point that you made. Over to you, Kritika.
So we have two more questions. Shweta Sharma. Ma'am, if you could tell about the advancement that has taken place for victim assistance recently in Indian scenario.
Can you come again?
Yes, ma'am. So Shweta Sharma asked that what are the advancements that has taken place for victim assistance in Indian scenario with regard to victim assistance?
Victim assistance, see, we need to understand the victim psychology also. That is very, very important because of the trauma that they undergo, because of the adrenal pump and all that comes out of the trauma. Now, the memory power, memory gets fragmented and it gets located in different places. Now, by the time they try to understand what has happened to them, and by the time they try to come out with the facts, because initially when FIR is lodged, she may not be in a position to recollect what has happened to her exactly, because FIR is the first document which sets the law into motion. Now, any lapses or any irregularities that go to make the FIR, later on the enforcement officers will say that they are not being told to us in FIR. So, I mean, it is very, very important, because even the victim is nowadays, there is no provision that she can engage her own lawyer. So thanks to that UN declaration, again, it has given so many provisions to us. Now, this kind of an assistance, wherever, now earlier they used to say there has to be a case, medico-legal case, only then we'll examine the victim. But thanks to the amendment CRPC to 2013, where they say now, if doctor says, any medical doctor, if the girl approaches the medical doctor for some first aid and all, if they bluntly deny, even there is a penal provision that gets attracted. So they also have to assist these victims of rape. And NGOs, of course, they also have a lot of role, and the assistance, and they should be made aware. It says, because after all, victim doesn't know who are all the service providers whom she needs to approach and all, and what medical facilities she can avail, and then what if somebody denies the medical assistance, how she can again court is there to punish them and all. And even the zero FIR concept also, they are not aware. But only thing is, it is the awareness. And of course, the forensic nursing and all is the new disciplines that are coming up in the forensic scenario, where they say the counseling and the trauma mitigation, these things, a trained forensic nurse can be in a better position to give that kind of an assistance. So no, the problem is assistance is available everywhere, but it is ignorance on the part of the victim. Now the courts, the UN declaration goes a step ahead in saying that not only telling the victim that you have got these rights, and then making them aware that these kind of service providers are available, and a kind of information, giving them that this kind of information is also part and parcel of the judicial activism. So a lot of assistants are available. Only thing is awareness and insensitivity. I have already told that there is insensitivity on the part of the stakeholders of the criminal justice system. So they need to be sensitized, and that can happen only with the training. So training, if they are given properly, then they'll understand. Now they have understood the gender sensitivity, but when it comes to victim sensitivity, yet a lot of training programs have to take place, and then they have to incorporate in the curriculum a lot of inputs regarding the services that can be provided to a victim, and then what are the rates and all. These kind of awareness programs will go a long way in mitigating these problems. I think I have sufficiently answered the query.
Yes, ma'am. Thank you so much, ma'am. We'll take one last question by Sarah Simon. She asks that what does Indian rules of evidence establish as the minimum threshold for evidence in sexual assault cases? Who can collect the evidence? Can a nurse in the local dispensary collect evidence? Then introduce a module on forensic nursing in the nurses and community health workers curriculum. Multi-agency approach towards implementing forensic victimology at all India levels.
I'm afraid. Yes, there are a lot of provisions under IPC, CRPC, Constitution of India, and there is no bar. Only restriction that is there while examining the victim is that they should be trained. Any untrained nurse is not supposed to handle, because they do not know how to handle the victim, and then in the process they may be collecting a wrong sample, or they may be collecting a sample in a handling a wrong procedure and all. So only expectation from the judiciary is that they should be experts, because the very first question that they'll be putting in the trial is whether you are competent, whether you can take competent enough to collect the material evidences. And law also at times mandate that whenever such a serious offense is being reported, and whenever there is an examination that has to be, medical examination that has to be done, and whenever it is a rape cum murder, the law mandates that it should be done by a team of doctors, and then all of them need to sign that medical legal report. It is so unfortunate most of the time that many a times these reports, so-called, are not signed by all the three, the team. Only the main man or the chief examination medical examiner, he will only be signing, and the rest of them will not be signing. So it becomes a very important thing for the point for the cross-examination. They will say that who are all the people? Is it a consensus that has been arrived, or is it the opinion that has been expressed only by that expert? So these kind of questions will be endorsed for the cross-examination. So it is always worthwhile and advised that the examination should be done as stipulated in the act, and the right person, the expert who has experience in that particular field, is the one who has to do it while taking the assistance from the others. And another thing is, whenever it mandates that it has to be taken videograph, the videographs are not being taken, or even if the video is taken, it's not clearly seen. So it also becomes a very important ground for the cross examination, or for the defense lawyer who can point out on this, because it is, after all, his job is to discredit whatever the witness is saying, irrespective of whether the witness is an expert witness or otherwise. So we'll be giving a lot of room for the cross examination. So if we can avoid these things, then you won the case. And when it comes to nursing and all, they are at the very preliminary and then very rudimentary stage. Actually, they are at the beginning. So I hope these are not very far, that these subjects will become full-fledged subjects, and then practically they will be implemented. And then forensic nursing, no doubt, has a lot of role to play, not only in counseling and then preparing the victim for the examination and all, telling her that how vital these evidences are, how they are important, what precautions the victim has to take, so that these evidences are not lost in the process of transit. I hope I have answered the query.
Yes, ma'am. Thank you so much. Because we are running on short on time, we won't be able to take any further questions. Also, Akshay, Suresh, we are very sorry that we could not take your question, although your question was very interesting. We'll try to answer. We'll mail it to ma'am, and ma'am might respond to a question via mail. Proceeding further with the session, now I hand over the session to Dr. Krishna Kumar Mishra and Dr. Viju Vincent, and we'll begin with the technical session and the further presentation. Over to you, sir.
Thank you, Kritika. I hope you all can hear me. Since morning, I found such a great experience we are having with such great learning. Greeting from National Forensic Sciences University, Gandhinagar campus. Good afternoon to all the experts from India and abroad. My colleagues from Delhi campus, participants, and students. Now we are going to start our first technical session of this international conference, where 7 different presenters have been allotted their presentation. And all they are going to speak about the diverse field of victimology by discussing the finding of their studies. For a smooth development of this particular session, following would be the sequence we are going to follow. So please keep in mind the following sequence which we are going to follow for presentation. We will start with our presentation from Ms. Vidushi Sahni, then Mr. Ritin Joseph, then Ms. Mansi, then Dr. Nitesh, then Mr. Hemant, then Professor Sarah, and at the end, Ms. Priyanka will deliver the findings. Before we start this session, certain announcement for presenters as well as audience. All the presenters will be given a time of 12 to 15 minutes. And it is requested to all the participants and audience, if they have any question related to any presentation, please post it in chat box, and all the queries will be entertained after all the presentations are done. So we are starting this session with the presentation of Ms. Vidushi Sahni. She is the research scholar in National Forensic Sciences University, Delhi campus. And she is going to speak about the extremism in the Indian cinema, the scientific decoding of cinematic messaging. The timing of presentation is between 12 to 15 minutes. Ma'am, you are welcome to start your presentation. Thank you.
Thank you, sir, and a very good afternoon to everyone. Thank you for the opportunity for presenting the paper today. I hope my screen is shared and visible to everybody.
Yes, it is visible.
Thank you. So the paper that I'm going to present today, it deals with the issue that has been a matter of much debate since the beginning of cinemas worldwide. That's the impact of cinemas, the movies, on the society as a whole. Now, this paper that it particularly deals with and attempts to scientifically understand the trends in movies based on extremism and the larger message that they carry for the general public. So the objective, as mentioned, has been to understand these trends in the depiction of extremism in terms of storyline, the characterization, the depictions, and how it has been presented, the dialogue, etc., and also assess the likely study can have on the psyche of the viewers. Moving further, giving a shot of the method that has been used. A content analysis was done of about 18 movies that were selected, movies especially, of course, the movies that deal with terrorism and extremism as their central theme. And they were from 1990 onwards till date. So roughly a few movies every 1 decade. And the criteria was for selection, that is the basic criterion was, we studied the radicalized character, and also secondly, the character who's portraying it and the storyline of the movie. Those are the basic units of analysis that were used for the study. Now, of course, this has been purposive sampling because certain movies have been identified who deal with and are able to cater to the purpose of the study here in question. So before going straight to the finding of why this area of inquiry is extremely important, because when we look at this from the Indian scenario, in the Indian context, this issue becomes even more important, owing to the fact that Indian cinemas hold a unique emotional appeal over its viewers, and that the nation, it has grown together. If you look at it in the pre-independent era, there were movies, certain movies such as Bhakta Vidur, and there has been mention across numerous movies where ideas of anti-British sentiment and nationalism, patriotism were indirectly fed to the masses, sidestepping and overcoming the British censor board and overall. Then slowly, gradually, as we attained freedom, the movies did a wonderful job of portraying how the nation, the newly independent nation, was tackling with various social evils, financial issues, poverty, unemployment, and that definitely did pave a way for a lot of social change. And slowly moving ahead, we also saw that, and in the recent times, I think that era is still ongoing, the struggles of a third world country dealing with globalization and the needs for modernization of its viewers. Along with that, we have seen that with passage of time, there is a greater concentration of movies on violence, showing machoism, rebellion. That has been a phase that came along with that struggle between modernization, between third world struggles and globalization. So the idea is to say that movies have always played an extremely important role in India's social evolution, whether it's just a mirror of the society, or it's an inspirer or inspires the nation to do something, still again remains a matter of much debate. So here it's to say that this emotional appeal multiplies this impact, this known impact of the movies manifold, ensuring stronger association and identification. Here, I would like to quote certain studies. Like while doing the study, they went through various thinkers who have already written a lot on it, and among them is the power of hypnotic value. Movies lead to identification life as well. So, if you see in several instances in popular culture, we also see that real life attributions and certain have been in real life. We have seen that related to caste, gender, class. We see those attributions have come to truth. People have started believing into them. Whether they are true or not, that can be inquired into as well. So one among these studies that I have taken as to further my study into it, and one of the basic fundamentals is a study by Lives and Katz in 1990. According to that, a viewer of a movie can be divided into three broad categories. One is one who likes the character, has a positive feeling towards a particular character, and that's it. It ends there. Second is being liked. So there's a high value of relatability, maybe in terms of employment or personality or social circumstances. So there's a deep connection within the character, and they tend to offer a justification for their every action because of that. And thirdly is wanting to be liked. Now this part is the most interesting one, and I think in case of Indian cinemas relating to terrorism and extremism, it holds a lot of value and deserves a lot of further inquiry into it, because if you're wanting to be like somebody, you're likely to model their behavior in the real life as well, because you'll end up justifying every act you like, and somewhere inherently you tend to connect with the person as well. So with all this background of the literature that's available that has on the issue, in terms of Indian movies and their audience, this degree of identification grows way above, because when understood in the social and political environment in which it has evolved. So going back to the study of the few movies that was undertaken, it was found out that everywhere there was a latent justification for the violent behavior, and at the same time demonization of the state machinery. And for that, few basic themes were unearthed that were common, that were constant across movies in different forms. So to just put a few forward was, if you look at the apathy of the corrupt system that leads a group of young, law-abiding youngsters to end up killing a prominent political figure. But the entire youth, if you remember when the movie came up, the entire nation had a positive feeling for the youngsters, and likely so, because the way it was portrayed. Secondly, if there are also movies, a lot of movies which have shown that religion-based atrocities have led to disillusionment, where yet another unsuspecting individual becomes a terrorist just because of atrocities he or she had to face because of his religion. Similarly, yet another movie that was that shows that race-based and religion-based can actually make a person into terrorist if without any real fault of his or her. At the same time, social cruelty, sexual violence might push a particular person to become a bandit, and he or she might lead to perpetrate similar atrocities on other victims who are completely innocent and have done no harm to that particular individual. Another area of inquiry has been need for social identity that leads a particular person to become a brigand. So this particular movie that recently came up, it showed that because of lack of social need for social identity and social ostracization faced in childhood, the person was legitimate to become a brigand, just to gain that respect that he much needed right from his childhood. However, and on the other hand, poverty, it is a common, I think, constant across all the movies, and a person who faced a lot of poverty, raised by a single mom, was an emotional character and turned into a gangster, an underworld don, just because of certain situations. While it might be all true to a certain level, but the presentation, the way the movies have been shown, the three basic understandings came to light after that, and certain questions that remain unanswered or might linger on in the minds of the viewers is that, is victimization a necessary part of the life cycle of an extremist? Or is extremism either, an extremism can either be an individual following a higher code, or avenging a personal misery that he or she must have undergone. And thirdly, that the state machinery is draconian and its victims are forced to turn into extremists. So it can create a lot of lopsided thinking and impact the youngsters to a lot of extent when they come to perceive the role of state and law and order in a country. So to further strengthen this literature review and the content analysis of the movies, a very small pilot was conducted with a group of around 30 students, 30 youngsters. We identified certain youngsters between the age of 16 and 19, and they divided into 3 focus groups, and they were requested to watch 3 different movies. Now the movies selected, all the 3 movies, that is Pushpa, New York, and Omerta, they show a evolution of a person, a normal person, into an extremist. In case of Pushpa, a brigand, the movie is loosely based on a real-life brigand Veerappan, who faces a lot of struggles in childhood and becomes a feared and infamous smuggler. And similarly, in case of New York, it's a very happy-go-lucky individual, a youngster who is illegally detained, and the movie is in the backdrop of the 9/11 attacks that happened in US, illegally detained, questioned, which ultimately forces him to become a terrorist. And thirdly, the movie is Umarta. It shows the evolution, yet again loosely based on a known terrorist, how he becomes a terrorist right from his young age till finally achieving becoming at the helm of the syndicate. Now, in all three movies, they have rightly portrayed, they have rightly shown what is happening in the society. There is nothing wrong, but what differs is the emotional appeal that has been attached to each and every character right from the beginning. So very interesting findings came up that the discussion post the first two movies was mainly based on the emotive aspect of it. The viewers tended to empathize with the two lead characters and the disillusionment with the system, and at the same time some of them even agreed with the stand, because with so much of trauma and tribulations they had to undergo, becoming an extremist or a terrorist or avenging their hatred like that was only a natural course of action. However, after watching this third movie, it was interesting to note that the discussion was a lot constructive. There was less of emotion and a lot of ideas, while it did show the role of family institutions, state institutions, law machinery, everything was there, but that was identified more as challenges that need to be addressed rather than a hopeless situation of a person who is forced into it and demonizing any of the aspects or any of the aspects of the criminal justice system. So here, this very small pilot did actually lead us to believe that there is a lot of scope to further dig into this area, because considering this importance and with information revolution, I think movies definitely have always had a lot of emotive impact on the people. So there's a proposal, and in fact, I would like to have the advice of all the esteemed dignitaries present here on if it is possible. I'm still exploring this zone to further analyze this area by conducting EEG on the participants, willing participants, of course, and analyze which centers of the brain are actually triggered if a person is exposed to a particular emotive scene, an inflammatory dialogue, a song, or a certain type of cinematography that can actually lead him. So is there actually any impact on them? And of course, taking into impact the personality of the participant, the aggression, age, and all that might help us actually come to terms with certain finding that these movies can have a lasting impact. Or if not lasting, they can drive a person towards a certain thought process that can be hazardous to him or to the society at large. So with this, I would definitely request for certain suggestions in this arena. And I think the basic objective of the study is to ensure we need to understand and look at films as a pedagogic tool. We need to acknowledge that there is a lot of need for media literacy.
Please conclude.
Yes. Yes, sir. This is the last slide, and we have to ensure that they do not become passive consumers of this powerful media and promote awareness of this in films, ensuring dynamic attitude towards them. Thank you, everyone. That's it.
Thank you, Ms. Vidushi. Are you staying here? There is one question. As we said, we are going to ask question at the end of the session. So if you will be available throughout the session, so there is one question we will ask at the end of session.
Sir, I would request you if I can have the question now. I mean, I'm sorry if I can, because...
Okay.
Yes,
so there is a question from Ms. Sarah that by brain circuitry, do you mean the functions of part of brain, neuropsychology of criminal brain?
In fact, thank you. I am actually still trying to explore this area. Yes, if by conducting exactly like what you said, by conducting a EEG examination, if I can understand which areas of the brain are activated when in response to certain scenes, so that might, with help of some expert in the field, will help me understand that, how this is cognitively and effectively impacting the viewers of the particular scene.
Hopefully, I hope the answer must be given. I think, Ms. Sarah, you must have got the answer, the question you asked. Otherwise, I know that there is a...
Yes, thank you. Thank you very much. Yes, thank you.
Yes.
Thank you.
Yes.
Thank you.
Thank you, Ms. Vidushi.
Thank you so much.
Now I invite the next presenter, Mr. Ritin Joseph. Mr. Ritin Joseph is a research assistant at National Forensic Sciences University Delhi campus, and he's going to talk about the applicability of suspect detection system in Indian airports, railways, and seaports from victim perspective. And Mr. Ritin, please stick with the timing given. And I just request all the participant and audience that if we are going to entertain all the questions by then, that would be great. So Ritin, please start.
Yeah. Am I audible?
Yes, we can hear you.
Okay. Okay, so good afternoon, everyone. My name is Ritin, and I'm a research assistant. As
We can't
I
see your
mentioned.
presentation. We can't see your presentation.
One second. Is it visible now?
Yes.
Is it visible?
Now it is
okay.
visible.
Okay. So the topic, this is a proposed study. This is a proposed research study. So it is the applicability and efficacy of suspect detection system at airports, railways, and seaports. A victim perspective, and it is a theoretical review. So first of all, we need to understand what the suspect detection system is. Suspect detection system is basically a screening tool, a forensic psychological screening tool, which uses a single parameter, which is the GSR, that is the galvanic skin response, or EDA, that is the electrodermal activity, in response to detecting a stress that is generated when we are engaged in the process of deception. So the reason, so suspect detection system uses the same fundamentals as we use in polygraph, but instead of using multiple parameters, we use only one parameter, that is the GSR, as mentioned, because of the fact that GSR is considered to be the most effective of all the psychophysiological parameters when we are trying to detect the process of deception. So that is what suspect detection system is in layman terms. What are its advantages? Now, the reason why suspect detection system is used, or why I'm suggesting that it should be used in Indian airports, is because of the fact that it is it's a very compact system, like you can see in the image. It's a very compact suitcase which we can carry around, and it takes only 5 to 7 minutes to administer it on one suspect. So, whereas in polygraph, it takes us around 45 minutes with question formulation and everything. It would take more than an hour. So it is very quick, it is very precise, and the results are generated, which in a more simple format, which we'll get to eventually in the presentation. So SDS is widely used screening tool. So SDS is a tool which is used in Israel and in US and many other countries as a screen tool in border security checkpoints and airports. But when we talk about the Indian context, none of this technology is being used as or till date. Now, in the Indian context, we have around 12.5% rise in smuggled illegal goods based on the report of the print in the years between 2000 2019 and 2020, which is quite a big amount, quite a big exponential rise. And there is around 20 lakh crore rupees of illegal smuggled goods, according to the report of Economic Times in 2020. Now, that is a lot of black money, and that is going to affect the economy and everything that comes after it as a whole. So why is it not being used in the Indian setup, even though we have international domestic airports, seaports, and railways which are used by millions of people on a daily basis? There is no amount of screening, no amount of security checkpoints. Besides, we have in some airports we have the thermal scanners. In Mumbai, they've started with the thermal scanners, but besides that, we don't have any other sort of scientific approach to screening. So these are the statistics and the facts, and with respect to the Indian context. So the background of the study is that using a system of this nature can help reduce crimes of this nature, that is smuggled, illicit, illegal products, to a large extent, right? And SDS is proved to be effective. Then why is it not being implemented in the Indian context? Now, the reason behind this is because of the lack of awareness or education in because most of us don't even know that a system like suspect detection system actually exists, besides people in the forensic psychology or criminology background. So this system is actually being used in most FSLs, DFS, and CFSLs in our country. It's been used by most officers, and maybe Sharda ma'am knows that even in their psychology department, maybe it might be used. So when we did our internship at DFS, it was used on almost a daily basis. We'd have cases for SDS screening on a daily basis because it's very effective. So why not implement the same in the airport and railway security checkline? So we need to implement this this idea and try to see its applicability in the airport setup. Now, we have challenges which we'll get to in a while. So in talking about the victim perspective, if you talk to most of the officers in the psychology department from different labs all over the country, most people give consent for polygraph or for any sort of lie detection or deception detection because they want to prove their innocence. So if you are wrongly accused and you are being victimized because of a wrong accusation, you can help prove your innocence by going through these psychophysiological tests like SDS or polygraph. So even in the airports, what happens is the airport security, they use I had a conversation with Hari Kumar, who is an IRS officer in Customs, Trivandrum Airport, and Krishnendu, who was a deputy commissioner of Customs in Trivandrum Airport. And they were very fascinated by the idea of using SDS in the airport screening because they do not know about any sort of technology like this, and they seemed very enthusiastic in having a trial run for this. So what they said is they usually use their hunch. So that's how officers usually pull out someone from a line by basis of the intel that they get from IB and from RAW, and their basic hunch is what they use. So it's very subjective in nature. It depends from person to person. How is hunch objective in any nature? So we can get rid of that subjectivity, that human error, by using something more scientific in nature. So that is why we want to promote the use of SDS in security screening in airports and railways. And also, it's a fact that we're producing a lot of forensic psychologists and criminologists in our country from various institutes like NFSU, but and their use is actually needed in the country, but it's still not implemented yet. So this could provide a lot of job opportunities also, actually, to mention. So the aim of the study is to check the applicability of the SDS in screening of possible suspect with malicious intent or smuggling of illicit goods or illegal immigrants in the airport. And the scope would be, the study would be restricted to anyone who is suspected of any malicious and criminal activity in the airport premise that the security personnel want to specifically check or screen immediately. This is the hypothesis if it will be effective or not. So the methodology that we would be applying is that the participant selection will be purely based on this hunch that the officers have. And if they really want to screen someone, they can take a larger group of people for screening because it honestly takes only 5 to 7 minutes to screen someone from the line and they have to catch a flight. And if you only need 5 minutes to screen and see if this person is hiding something or is deceptive about something, we can screen that person in just 5 to 7 minutes, which is a big advantage. So after the person is brought off from the line to the place where the test needs to be conducted, the consent will be taken from the person for because that's how it legally proceeds. And the advantages is, one, because it takes very less time. And second, the data collection and the storage will be done onto the SDS online server. So in Polygraph, what happens is when you run a Polygraph test and so on, to generate the results, it takes a long time. So we also have an OBS system, that's an automatic generated scoring system in Polygraph, which is not very accurate, and I don't think a lot of officers use that. So it's a long time taking procedure, basically. And what I'm trying to say is that SDS, though, the Incogito system in SDS, it calculates the test results are generated right after the 5 minutes of the test. So it's automated. And it's very accurate. It has 94% of specificity. So it's very accurate. So the system generates the result, and all you need to do is, if you want to proceed, if a person turns out to be a suspect or an unsuspect, you can proceed by reading the graphs if it's a specialist. And that is just from current. Is this slide visible? Yeah. So you can see that there is this GSR raw data, which shows the amount of variation in the GSR and the emission of GSR. And the pink lines are basically the time frame in which the questions have been asked. This is the reaction strength. You can see yellow is the abnormality level. The blue is the peak of tension that is generated when we get to the relevant question, which is usually placed on the third or the fourth, which is technical, which we don't really need for this right now. And you can see the wavelet analysis, which shows the peak of tension, the normalized skin conductivity versus the reaction, the weighted reaction volume of that specific question, and the abnormality level over here in the last chart that we have. So if you want further reading, and if there's a forensic psychology specialist, you can go into further readings to see if the test needs to be conducted with a different set of questions altogether. So to conclude, first, the reason why this research should be conducted is because it would, if it turns out to be successful, then it would give an effective screening in a very short period of time. So we can screen a large amount of people in a very brief amount of time. So that makes a lot of sense when we are and in terms of victimization, if someone is picked out of a line, wrongly accused, and if they miss their flight and if they turn out to be innocent, then that causes a lot of other problems. So if we can screen them in just 5 to 7 minutes, then it turns out to be a very good advantage for people in the customs or immigration department. And the third point is objectivity. We can get rid of that subjective human errors that comes from basing everything on a hunch, and we can get rid of that subjectivity with an objective scalpel, and we can look into it with the most scientific scalpel basically to it. So it would improve the security sector, and it would help reduce false accusations, which might lead to victimization. So this is basically the research and the analysis. We can do a t-test because we have two groups. We can have a control group of people who turned out to be suspects and people who didn't, and we can compare and see how effective the results actually are. So yeah, I think with that I come to an end of my presentation.
Thank you, Ritin. Hello.
Yeah, you're welcome, sir.
Thank you, Ritin. I request audience and participant to please post your question on the chat box, which we will entertain at the end of our presentation. So we have up till now we have two presentations. One is from research scholar, and one is from a student. Now I would like to invite Steve in post-mortem forensic toxicology and criminal justice system analysis of the current scenario. Ms. Mansi, you are welcome to present.
Thank you, sir. Thank you so much for the such an introduction. Hello, everyone. This is Mansi Trivedi. Let me share the screen, please. Is my screen visible to everyone?
Yes, it is visible.
Thank you so much, sir.
All right, as sir already introduced the topic, that is post-mortem forensic toxicology and criminal justice system and analysis of current scenario. Well, instead of going to too much of technicalities, as I am also learning with respect to what is forensic science, what are the different aspects of forensic science, I would like to talk about the evolution and the background of the forensic toxicology and the victimology and the problems that are being faced by the victim. Technology in the modern world has evolved to new forms that were unpredictable. They have also lead to different forms of issues related to the crime scenario. Now, it is important that the courts which pronounce justice to the citizens, but this justice has to be based on some evidentiary value, or there must be some evidentiary aspects which has been established by the principle of natural justice and forensic science. And the procedures have a significant role in the attainment of this objective. Autopsy, when we're talking about postmortem, autopsy is another word which is often used as synonym to the postmortem. And the meaning of this particular word is from Greek origin, which means autovia, which means looking at oneself. The entire procedure is one of the essential practices for establishing question of law by scientific application, and it is an integral component of the forensic science. This particular arrangement is again quite helpful when it comes to the questions like what is the reason behind any kind of death that is taken place, whether the death has taken place, whether it is natural or unnatural, because it is one of the most extreme phases whereas the victim in itself cannot speak for himself or herself, and which is even more important for the courts to understand. Just giving an example of one of the cases where the court has said, that is in Pappu versus state of Uttar Pradesh, which came in 2022. The court said that when ingratitude is shown instead of the gratitude by killing a member of the community, which protects the murderer himself from being killed, or when the community feels that for the sake of self preservation, the killer has to be killed, the community may well withdraw the protection by sanctioning the death penalty. Now, when we are talking about this particular court, well, it is very important that the community must, it is very important that we must understand the importance of the victim. We must understand how preservation is required and how the community can come together with respect to understanding the mindset of the victim. Coming to the background of the postmortem, it is a process that involves the procedure of the examination of the internal and external organs of the victims, which was established, the first procedure which was established in Egypt around 4000 BC. Right from embalming to autopsy, they were found to be quite efficient in the pathological studies. In fact, this is why the Greek physician, Mr. Herophilus, he said to be the first anatomist who performed autopsies on humans and animals on a regular basis. The first autopsy which was conducted, it was conducted on the, Julius Caesar, so as to establish that why he died. Again, when we are talking about the significance in India under Section 174 of CRPC, it also provides that police officer has certain obligation to ascertain if the death occurred under the natural circumstances or not. So an inquest can be drawn, which is an exceptional circumstances. If the police if the police thinks or the officer thinks that it is required, then in that cases it can take the assistance from the doctor also. Coming towards the significance of the significance of the this has helped the process of identification and establishment of the crimes and how the crimes have been done. Coming towards the involvement of the human beings with the rapid increase in the form of crimes and the different kinds of phrases like war crimes, the communal violence, the murders that are taking place, we cannot deny that there is a wider form of mutilation to the human body that has been done. Now, this often leads to the remains that it is sometimes it is unknown to whom this what is the identity of anthropologists, pathologists, etc., and forensic experts respect to how they and eventually help in establishing their identity. The body is then sent to the mortuary or the morgue where the dead bodies are deposited. But after which the body is eventually investigated in the autopsy room and a post-mortem investigation report is drafted. Particular report is a complete detail regarding the factors like what is the time of the death, when the what is the manner of the death, how did it take place, what are the various substances which was found around, what is the intoxication reports if there is any, whether the person has been poisoned or not poisoned, whether the organs how and in what condition the organs of the human body was found. So, with the rapid evolution in the form of crimes, it is necessary that there need to be a important number of the experts which can have proper expertise on the particular area, and such equipments are required or such standardized equipments are required which can actually go for a proper examination. So instead of now to conclude with the presentation, Ministry of Health and Family Welfare, in its official memorandum in 2000, conducted only if there is a proper equipment that is provided with the or which is available with the particular hospital. Also, with respect to the legal purposes and to come to a proper legal conclusion and for legal and for future legal aspects, a video recording should be taken for the post-mortem so that it can be utilized for the further in the cases and where it is technology, or when we are talking about how a victim can be identified or how a body should be identified during the autopsy. Thank you so much for this, for providing me this platform for the presentation. Thank you, sir.
Thank you, Ms. Mansi. Now, our next presentation is done by two people, Dr. Nitesh Jha, who is the professional, and Ms. Sanya Kapoor, who is a student. They both are from Sri Guru Gobind Prize and Trinity University, Gurugram. And they both are going to talk about personality as a predictor of rape myth acceptance among rape victim and empirical evidence. So, you both are welcome to present.
Good afternoon, sir. I hope my PPT is visible.
It is visible.
So, good afternoon, everybody. As sir rightly introduced, I and Dr. Nitesh Kumar Jha have worked on this research presentation. However, I will be presenting this presentation under the supervision of Dr. Nitesh Kumar Jha. So the topic is personality as a predictor of rape myth acceptance against rape victims. Now, I don't want this presentation to just be an informative one, but also be an eye-opener, because I think, according to me, this is the need of an hour. So moving further, we are all aware that the rape cases in India has sparked. So since the last decade, according to the statistics as well, rape is the fourth most prevalent gender-based violent crime in India. So there's been multiple researches done on the rape victims or the criminals or the rapist. However, I wanted to understand the non-criminal population, which in turn suddenly turns into a criminal and conducts certain heinous crimes like rape. So I came across this concept of rape myths, which are those prejudiced and stereotyped false beliefs about rape victims. So to understand more about these myths can be divided into multiple domains. Some domains could blame the victim as though the victim asked for it, the victim wanted it, or the victim lied about the circumstance. The myths could also blame the circumstance, that the circumstance wasn't really rape, or rape is a very trivial event and it is normal to be a part of it or whatever, and rape is a deviant event, that neighboring are something which are really infuriating for me. So considering these myths, there were a lot of variables which predicted these myths, be it an individual's view about sexism, their cultural factors or environmental factors. But what caught my eye was the personality, because personality is that domain which shapes an individual. And how does personality is a major component of a research, which is a single factor which could actually predict these rape myths of an individual. So for my research, I chose the Big Five Factors of Personality by McRae and Costa, which is openness to experience, conscientiousness, extraversion, agreeableness, and neuroticism. So I did multiple reviews of literature, and surprisingly, there were very less studies which were done to relate personality with rape myth acceptance. Some of them did find extraversion as being correlated negatively with rape myth acceptance, but all the researches were in the Western context, which comes to the fact of the need of the study. Since the studies which were earlier done were on the Western context, I wanted to know more about the Indian population because I found there is a gap in knowledge. And also, if we look at statistically also, according to BARCC, 1 in every 4 women may experience rape and sexual assault. So for somebody in psychological field or mental health care practitioners, they will inevitably be dealing with this population. So knowing more about this concept is really important. So the objective of my study was to investigate if the Big Five Factors of Personality predict the domains of rape myth acceptance. I formed 5 hypotheses according on the basis of the 5 factors of personality. I chose a cross-sectional study design, and to understand the view of the Indian population, I collected my sample from 26 different states in India via online mode, considering the pandemic. My gender frequency was 88 for males and 209 for females. I used 3 tools. First was a basic socio-demographic detail and consent form. Second one was the Illinois Rape Myth Acceptance Scale. And the third one was the Neo-FFI Inventory for Personality. Now, I thought that to reach out to the masses, I would want that the questionnaires would be shared, keeping both Hindi and English language translations for each item, so that the individual could understand the concept better. Moving on to the statistical analysis, I chose descriptive analysis for the graphs and describing my sample. But for the main prediction part, I did multiple regression analysis. So if we look at this table, I've done a stepwise regression analysis for all the 5 factors and all the 7 domains. And I've only mentioned the factors which actually predicted the different domain. If you look at the first one, for example, the she asked for a domain is predicted by neuroticism, which can be seen as the F value is 74.4, which is significant at the 0.001 level. So looking at like this only, looking at all the 7 variables, we can see an overall trend that neuroticism predicts each of the domains of rape myths. However, the other factors of personality rarely do. Conscientiousness, for the matter of fact, predicts only 2 domains, which are it wasn't really rape and she lied, and openness to it, which also said that neuroticism predicted sexual violence and coercion. Now, sexual violence and coercion is not directly related to rape myths, but again, rape myths can lead to the majority mentality of the non-criminal population turning into criminals is actually the root from where rape begins. So talking more about this topic and researching more, doing qualitative analysis, quantitative analysis about this topic would actually help. And my main aim is to influence the policy makers to aid in the planning and implementation of certain rape preventive interventions, which can actually target the personality and the root cause of rape, so that in future, the victims against whom these myths are held are not a problem in the future. So this was my study, and here are the references which I used. And overall, I would like to thank all of you for your time and attention, and I hope that this is not just as an information, but also as the need of the hour to get reform. Thank you.
Thank you. Thank you, Ms. Sanya, for your presentation. Now we are moving to next presentation, and the next presentation is again done by 2 people. They both are the student, Mr. Hemant Sharma and Ms. Jagjot Kaur, and they both are from National Forensic Science University Delhi campus, and they are going to speak about the topic burning in hell, acid attack survivors. So you both are welcome to present.
Good afternoon, sir.
Mr. Hemant, neither we can see
Yes.
you nor we can see your presentation.
Sir, we are presenting it,
Okay.
sharing the screen. Sir, is my screen visible?
Yes, yes, it is visible.
Okay. Warm good afternoon to Honorable Chairperson and Co-Chairperson, speakers and presenters. I, Hemant Sharma and Jabjot Kaur are presenting a presentation for our paper titled Burning in Hell, Acid Attack Survivors. The purpose of our study is that we believe that this issue resonates with us and we want to empower young women out there so that they can take charge of their lives. This is an issue that needs more awareness among youth and stricter implementation of laws. So let's start with the introduction. In an acid attack, a person throws corrosive acid at a young woman, generally on her face, with the intention of seriously injuring her and upsetting her socio-economic situation. In cases of domestic violence, the husband or in-laws may use this as a means of retaliation for rejection of sexual advances, affair proposals, or other advances. They may also use it to demonstrate their superiority. The Acid Survivors Trust International reports that 1,500 incidents occur worldwide and that 80% of the victims are women, making it a crime against women. In most of the incidents where target men are involved, an Indian property dispute is what has caused such severe harm. In India, acid attacks are a significant issue. It is a terrifying act of violence against women. India tops the charts when it comes to acid attacks. A country where the sale of acid over the counter was banned in 2013, we have too many cases, and most of where women are attacked as per domestic violence or for dowries. It has numerous negative effects, including excruciating pain, irreversible facial disfigurement, multiple sorts of infections, blindness, and most importantly, mental health issues. Slide is showing the data from 2014 to 2018. So this slide is on the y-axis, we have the number of victims, and on the x-axis, it's showing the years, the data from 2014 to 2018. In the yellow color, it indicates the incident number. In the red color, we have the number of victims, and in the blue color, we have the number of people who were charged. So this particular slide is showing that with each passing year, the number of victims is increasing or staying constant, but the number of people charge sheeted is decreasing, or the number of cases that are being reported to the police is decreasing. So that's an area of concern. This slide is showing the horrifying menace that is the acid attacks and how many cases there are in various states in India. So the highest number of cases are from Uttar Pradesh and West Bengal, and this data we have collected is from 2014 to 2018, and currently even to this day in 2022, the cases of acid attacks are highest in Uttar Pradesh and West Bengal. The latest crime data for 2018 from the National Crime Records Bureau, that is the NCRB, shows that acid attack cases are constantly getting transferred or sitting in police files for years. This is shown by the data in Indian courts. 523 cases were slated for trials in 2018, which are up to 407 in 2016 and 442 in 2017. So while total number of registered cases in a particular year are on a slight decline, the fact that very few cases are disposed of in years is symptomatic of how slow the justice system is. Now for the further slides, my co-presenter Japjot will be taking them.
Thank you, Hemant. Section 236A of Indian Penal Code consider acid attack as a punishable offence. Retribution for this offence is under Section 326A. Punishment for administering an acid attack is a minimum 10 years, which may extend to life imprisonment upon the judge's discretion. The punishment for attempting to throw acid on a person is punishable for a time period of 5 to 7 years under Section 326B. Irrespective of the nature of the damage caused to the victim is liable for compensation up to rupees 3 lakhs. The compensation should be payable in addition to the payment of the fine by the offender. Other countries have also taken some steps to control the acid attack cases. For example, Bangladesh has banned completely the sale of acids. Also, there are also NGOs working in India which work for rehabilitation for the acid attack survivors. For example, there is an NGO, Delhi-based NGO known as CHOW. So, example of this horrendous act was of Lakshmi Agarwal. Lakshmi Agarwal, it occurred in the tragic events occurred in 2005 when 15-year-old Lakshmi of 11th grade was contacted by Naeem Khan, a 32-year-old man who worked in her neighborhood. He proposed to Lakshmi, but she rejected the proposal. 10 months later, Lakshmi Agarwal received the same message from Naeem saying he loved her and wanted to marry her. She made no comment. Kamran's, Naeem's older brother, and Naeem quickly threw acid on her face and ran away. Lakshmi underwent multiple operations, including eye surgery. 4 days after the attack, Naeem Khan was arrested but was bailed out a month later. He married off immediately. However, after widespread protest and media attention, he was sentenced to prison for life. But there are still numerous examples of acid attack survivors whose convicts did not get the punishment they deserved. Such women receive very little justice from the law. Another example of this was of a girl, Fakra Yunus, who was a dancer in a red light district area in Pakistan. When she met her future husband, Bilal Khar, the son of Ghulam Mustafa Khar, who himself is a former governor and chief minister of Pakistan's largest province, Punjab, they were married for 3 years, with Yunus eventually leaving him after she claimed he physically and verbally abused her. She further claimed that he later visited her in May 2000 and poured acid on her face in the presence of a 5-year-old son from a different man. Khar claimed that the attacker was someone else with his name. Eventually, he was acquitted with all the charges. Italian NGO head by Clarice Felly entered Pakistan to assist in the care of mutilated women. Unfortunately, Yunus, at the age of 35, committed suicide by jumping from the 6th floor of a building in Rome. Her body was brought back to Pakistan by Durrani and was wrapped in an Italian and Pakistani flag. So, with the case study of a few cases from the Indian subcontinent, our study will investigate the psychological harm caused by acid attack victims. Through this presentation, we hope to raise awareness of a social issue and bring change in the mindset of people. We set out to analyze the issue and find a workable solution. So, our methodology was secondary data, including NCRB reports and data from several research papers was collected for the presentation. Further, primary data included and physical recovery of the victims. CHOW, which I mentioned earlier, is a Delhi NCR-based NGO working for the rehabilitation of acid attack survivors. So, to conclude, the victims should be treated with compassion, respect, and dignity. Restitution should be a part, should be the assimilation of survivors. Victimology is another name for acid attack assault to educate young women regarding various laws and their application in day-to-day life. The objective is to change mindset of people through education and awareness by including took for our presentation.
Presentation. Thank you very much.
Thank you, Hemant and Jyot, for your presentation. Now I request Professor Sarah Simons. She is the professional at Seafarers International Research Centre, Cardiff University, Wales, in UK, and she's going to speak about geospatial analysis of variations in ship crew, maritime piracy victim self-identification. Please, ma'am. Hello.
Opportunity to share. Thank you very much for this opportunity to share my research findings. My name, as you've been told, is Sarah Simons. I'm just going to display my presentation. Give me a second. My presentation is based upon a research that I did between the year 2011 and 20. Oh, there it is. Thank you very much. So I'm a research fellow at the Seafarers International Research Center, but at the same time, I am working right now in Somalia. I'm the vice president, one of the two vice presidents of the World Society of Victimology, so I'm quite passionate about victim matters. But today I'll focus the next few minutes talking to you about one of the research findings of my study, which I'll tell you about, which will focus mainly on the geospatial variations in victim piracy self-identification. So what that means, geospatial means how it varies from place to place, how the victims identify, the individuals affected identify as victims of maritime piracy, and how this variation, how the difference in their feeling of safe or unsafe, vulnerable or unvulnerable, changes from place to place. And this is based upon the empirical data from this study, which I conducted at the Seafarers International Research Center with a generous support from the Nippon Foundation of Japan. Seafarers International Research Center is located in Wales, in Cardiff University based in Wales. I know there is another Wales in Australia, but the Wales where I was based in is in the United Kingdom. The thesis title is there before you. I analyzed maritime piracy, and I'll tell you what my working definition is. And the piracy specifically in East Africa between 20 and 2010, and how it impacted on seafarers' occupational risk, how the attacks, the piracy crisis, influenced how seafarers, that's ship crew, people working on ship, how they regarded their workplace, how they regarded the ship where they worked and the different aspects. The study period is, as I told you, and I mainly targeted active seafarers, people working on ships. I looked at a heterogeneous sample of 44 seafarers, and to focus mainly on the risks that they face in their workplace. I think that I feel quite proud of this work because up to this point, I had not seen any victimological work focused on the maritime environment. Maritime means at sea. The sea comprises of 71% of the Earth's surface. It is a completely a global world of work, and not much research in the victimological sphere focused on that. I wanted to look at the occupational risk landscape of the maritime environment to highlight the hazards. It is very hazardous. Maritime piracy has two definitions currently accepted, the one by UN Convention Law of the Sea and the one coined by International Maritime Board, to be able to capture not only successful attacks, but successful boarding of ships, but also failed attempts, but not only at sea, also while they are docked in port. And I would like you to pay attention to the UNCLOS definition, because we are going, whether it talks of violence or detention, that's hostage taking, or any act of predation, how the crew are treated, committed by individuals for private ends. This is a very important definition because when pirates take you, and we will see what happens in a piracy attack, they're not just taking you to feel nice and take photos on a ship. They take the hostages, they take them hostage. In East Africa, it was a kidnap for ransom. The IMB definition is important because during when people sneak into ships in the port, some of my people on my sample talked about being attacked on the ship while it was docked in port in a certain ports in West Africa, and how things were stolen from them. That fits within this. I'll keep referring to West Africa because the maritime piracy hotspot in the world keeps changing. Before East Africa, it was Malacca in Indonesia. After East Africa, it's moved to West Africa, and it keeps moving. We're going to look at these vulnerabilities in terms of victim situation exposure, how the amount of the actual exposure or vulnerability faced by the victim results from the environment. I won't look at the personal traits, I'll focus on the work environment. So when we talk about seafarers and when we talk about their risk perception, is how they perceive of the hazards. The seafaring is the working on any ship, whether it's a fishing ship, a cruise liner, an oil tanker, at sea. I found that the seafarers' perception is not unrealistic. They face many, many hazards which you and I would agree are very hazardous and life-threatening. It includes fires on the ship. It includes people falling overboard into the sea, and the sea is quite very deep. Attacks by pirates, collision. It involves collision. It involves being stuck on a ship, and we'll see why that. I also find that piracy, because it was a crisis, it was like a lightning rod. It attracted all other fears, and there were many variations in the occupational risk, and it was not just influenced by age and nationality. It varied from different settings, and the ship itself acted as a lightning rod, attracting, as a risk amplification centers, because they share stories about it and it amplifies their risk. The second angle at which I look at exposure is that now from the view of the seafarers, all these ones are different attacks, and this is the area I focused on because it was the hotspot. The individuals felt vulnerable. They felt that no seafarer is safe because they were the targeted victims. Pirates were not interested on the goods on board. They were interested in kidnapping the seafarers, holding them holding them hostage for ransom. So it was a kidnap for ransom. And these are the reasons highlighted why they felt exposed. Seafarers work on ships going to different parts of the world. And this Suez Canal is a shortcut for any ship going west or coming east. So therefore, they were bound to cross the Suez Canal, and piracy rising from individual incidents to the major big enterprise it became. was a major concern. It was a major concern to all my interviews, whether or not they've worked in East Africa. And I interviewed seafarers from different parts of the world at a UK port. And one of the things that this exposure did to the seafarers is that it caused them to be fearful, to listen to the words used. Even if you're not in that area of the world, there are alerts usually sent to the ships. There were areas that are called high-risk areas. So even before they go there, they're told, they say that that there is a risk. So they feel that they're targeted. Whenever they have to go through some high-risk areas, they go through drills. So even if they were not thinking, they have not experienced, they have not met pirates, they think my life is at risk. They became hyper-vigilant. They talked of a heightened sense of vulnerability. They said your life is 50-50 when you go through those areas. So they were, as they moved from area to area, the concern, the piracy crisis increased their concern. When there is a piracy incident, it happens in stages, day or night. The pirates pursue the ship, they shoot at the ship for it to stop so that they can board. And the ship is quite high, but normally they end up boarding. They manage to board if they're not deterred. After boarding, they take control of the ship. They commandeer it. Captain has no control over the ship after that. You have no to. That's followed by a hostage. The time when they're held hostage because ransom is being negotiated. These are some of the crew from the part of the world which has sent many crew. They were held for 4 years. During those 4 years, you have no control over your life. These ones were held on their ship. These ones were held on land. So they can be held either way, but you have nowhere to run. So the notable situation factors I'd like to highlight as I finish this one is that the seafarers' views are what I wanted to collect. How do they perceive of it? Because previous studies had focused on seafarers as numbers who are held hostage, number of days they were held, number of ships, but it had not given the opportunity for seafarers to talk of their study. They say it is scary. It is scary to pass the piracy area. Piracy is not a problem, but it's only a problem in the Somalia area. Or when we enter that area, it is dangerous. So therefore, the two main factors are the location of the piracy occurrence and the proximity. That is what distinguishes the geospatial analysis from other analysis. It locates and situates the threat factor and the heightened sense of insecurity to specific areas. So some of them could avoid contracts taking them to some areas, some could not. And they said, for example, I'm worried and insecure when we pass Somalia. Another one said, when we pass East Africa, I become nervous because it's a piracy area, meaning other areas are okay. India is okay, Australia is okay, but East Africa, oh, I'm worried. I prepare myself for anything to happen, they said. Some of them just said, I don't care. My ship doesn't go in that area. So there were senses of, and this is my last slide, there was talk about the geospatial variations. There were some things that influenced the fear. And there was also what was mentioned earlier today by Brent, intersectionality.
Professor Sarah.
And finally, self-identification.
Sorry to interrupt you.
Professor
Sarah, please, can you please conclude?
Yes.
Please.
Yeah, this is my last slide.
Okay.
Yeah. So these are the three areas under which the self-identification can be looked. And it is not an easy thing because the risk perception is a complex worldview constructed from a convergence of forces, whether at land or at sea. The fear and the self-identification is across a spectrum. I'll submit this to the organizers so you would be able to contact me in case of any. Thank you very much.
Thank you, Professor Sarah, for your presentation. Now we come to the Professor. Thank you, Professor Sarah. Now we come to the last presentation of this technical session, and this is going to be presented by Ms. Priyanka Samuel. She is the professional at the School of Behavioral Science, National Forensic Sciences University, Gandhinagar campus, and she is going to speak about couple relationship experiences, a gender-based approach. Ms. Priyanka, please present.
I'm going to present about couple relationship experiences, a gender-based approach. And the paper is authored by myself and Dr. K.K. Mishra. So we all know that marital satisfaction is crucial in every marriage. However, the experience of happiness and satisfaction can be relative and subjective as per the cultural factors of the society. A positive association between life satisfaction and marriage is well established in the available literature. However, research indicates the possibility of difference in experience of couple relationships in terms of satisfaction in marital relationships, which is a clear indicator of happiness in marriage. The experience of happiness and satisfaction can be relative and subjective as per the individual and cultural factors of society. Several factors determine satisfaction in marriage in males and females. Satisfaction is subjective, higher interpersonal conflict, the difference in perception of sexual behavior in men and women, the power struggle and low self-esteem can lead to low marital satisfaction in women. Men are found to be benefiting more than women from marriage. The most common factor that supports a more significant benefit for men is unequal distribution of work in terms of household and childcare in the families. However, there's a significant change in modern era where women are associated with shouldering the financial load with men. Women are more likely to approach and commence marital therapy, and women are found to be high marital conflict and low marital satisfaction. So, association between marital satisfaction, marital adjustment, and marital conflict in married couples, and to examine the gender difference in reporting of couples on marital satisfaction, marital adjustment, and marital conflict. The study variables, they were marital satisfaction, dyadic, and included cases diagnosed with severe psychiatric illness, epilepsy, and mental retardation, history of serious medical and neurological condition, education level less than 10th standard, duration in one or both of the partners. The tools that we used was revised dyadic adjustment scale by Busby et al. It has three subscales. One is dyadic consensus, which is the level of agreeableness of spouse with the partner. Second is dyadic satisfaction, which is satisfaction of marital relationship with the partner, and dyadic cohesion, which is the degree to which individual and partner participate in the conjoint activities. The second scale which we used was couple satisfaction inventory by Funk and Roch, and Kansas marital conflict scale by Egerman and Mockery et al. So results revealed as per the correlation values for dyadic adjustment, couple satisfaction, and marital conflict variables, they were found to be significantly correlating. And there was a significant value on t-test. And there was a significant gender difference. In dyadic adjustment. So a positive correlation was observed between consensus and satisfaction, consensus and cohesion. Dyadic consensus is the level of agreeableness with the partner, which also is a strong indicator of togetherness of the couple. Couples who have consensus combined activities, cohesion. There was a positive correlation between dyadic cohesion and dyadic satisfaction, which means conjoined activities in married couples increase their marital satisfaction. So overall score, it can be hence inferred that greater adjustment in couples increase marital satisfaction. However, the term satisfaction is subjective in nature, and in couple of relations, deeper aspect of the relationship need to be explored in to derive a better picture of functioning of dyadic relationships. It can be inferred from the findings that high dyadic consensus, cohesion, and dyadic satisfaction, they are strong positively correlated with dyadic consensus, dyadic cohesion, dyadic satisfaction, and total dyadic adjustment, although it doesn't infer the literal positive association of the variables because of the scoring scheme of couple conflict scale. So, as per the scoring, high scores on the scale indicate low conflict in couple. So, hence the results reflect a negative and inverse association between couple conflict and dyadic consensus, dyadic cohesion, satisfaction, and total dyadic adjustment. So, coming to the implications of the study. So, the study has a clinical implication in understanding the couple experience and factors that can influence the quality of relationship. Preventive measures can be taken to deal with domestic violence, battered women syndrome, couple conflict, frustration in marriage, and divorce. Understanding of the factors that affect a couple relationship helps in developing therapeutic approaches to reduce a couple's distress. So, there are three aspects that we can take into account when we talk about forensic and clinical aspects of the topic. First is identification of the problem in couples, where the distress in a couple starts. So the first step is to identify that there is a distress so that it can be prevented and further managed. Coming to the limitations of the study was carried out on a small sample. A larger sample size will provide more generalizable results. And cultural aspects, they need to be considered because marital practices, they are highly influenced by culture. More variables can be explored, like relational connectivity, rather than focusing on marital expression. When a person can say that I'm satisfied, it can be just, a sense of being with somebody, like getting married to somebody with a status, or other superficial aspects can be associated. But when we talk about connectivity, so more meaningful aspects, they are associated, like sense of belongingness, compassion, care, transparency, friendliness. So these aspects, they add a lot of meaning to a relationship than just calling something like a satisfaction. So for a deeper understanding of couples reporting, further researchers may use mixed method, and qualitative aspects can be explored in future. These are the references, and thank you so much.
Thank you, Ms. Priyanka. Thank you for your presentation. With this presentation, all the allotted presentations for this technical section is over. From here onwards, I am handing over the responsibility to the co-chair, Dr. Vijo Varghese, to further the formalities. Dr. Viju, please.
Thank you, sir. Am I audible, sir?
Yes, you are audible.
Okay. Thank you, sir, again. Good afternoon and good evening to all those who are part of this first technical session of the International Conference on Forensic Victimology and on the advanced trends and future challenges of forensic victimology. So at the outset, I would request all the audience to post your questions in the chat area. And please address the questions to the specific presenter so it can be taken up in a minute or two. So forensic victimology, being a branch of applied victimology, is the need of the hour, which helps to engage in prevention, investigation, intervention, and public policy development on behalf of those who have been victimized. And Mrs. Sharda Avadhanam had lucidly placed before us the available provisions for the victims as stated in the United Nations instruments, and the challenges in the field, especially in the collection and handling of evidences, the processes that are being followed, the lack of resources and technology that contributes to the way our criminal justice system functions. And from Ma'am's vivid experience in the field, she had stated that collaborations among stakeholders in the criminal justice system is key to provide justice to the victims, which means that we have a lot of work to be done to become or have a very victim-centric criminal justice system. And I would like to congratulate all the paper presenters who showcased their research work by presenting the present trends and scenarios in a victim's perspective, and in also suggesting possible way forward to strengthen the various aspects of the criminal justice system to make it more victim-centric. For me, I personally found this session very informative, and I will be looking forward to the other sessions in this particular conference. So before we close this technical session, I would like to take a few questions that has been posted in the chat area. So I see three questions for the presenters. The first question is from Sanjukta to Ms. Sanya, and the question is, Ms. Sanya, can you please tell about the sampling technique that was used in your present study?
Thank you so much for the question, sir. And Sanjukta, as I mentioned in my presentation, I used a convenient sampling method wherein I spread my questionnaires through word of mouth and through the people who I knew were from different states. And again, they spread it further. So it was a convenient sampling method. Thank you.
Thank you, Ms. Sanya. The second question is from Chaitanya. I think it is directed to Hemant Sharma and Japjot Kaur. So the question is, I wanted to know about the current data on acid attack victims and if the victims have been have increased or decreased since 2018. And was there any action taken to make the laws more stringent?
Okay. So thank you, Chaitanya. So the laws from 2018 to 22 there hasn't been any changes in the law. The Art 32(6)(b) article under the Indian Penal Code still is same, although it does give compensation up to rupees 3 lakhs. In some cases where the case is very severe, the damages has been a lot, the compensation increases up to rupees 10 lakhs, but it still depends on the judge. Apart from the cases, if it has been increased or decreased, so there has been a slight decrease in the cases from 2018 to 2022. So the registered cases are 386, but in my opinion, we were in the pandemic for 2 years, so I guess the slight decreasing I guess that's a major reason for that. Also, there are always dark figure cases, especially in rural areas, so we cannot rely on the only on the statistics. Thank you.
Thank you, Japjot. I have another question from Kritika to Ritin Joseph. You had mentioned that your study was theoretical in nature. How do you propose to go about it in terms of feasibility?
As I mentioned, it's a proposed study. So this is headed by Dr. Beulah Shekhar ma'am from Delhi campus, NFSU, and she will be the principal investigator for this, and I'll be assisting her as a research associate. And we've already spoken to officers in the Customs Department and Immigration Department from Trivandrum Airport, and we will be doing so for the other airports over the country and the major railway stations. So it's been processed, and we have to execute the rest. So this is what the status of the research is.
Thank you, Ritin. I have one more question that was posted in the YouTube chat. This question is directed to Ms. Sanya. So the question is, the Illinois rape myth acceptance scale used in your research, what is the admissibility and reliability rate in Indian context? And what is the sampling technique used in your research? So you did mention about convenience sampling, but can you talk about the reliability and the admissibility rate of your tool?
Definitely. So as I mentioned in my study, the Illinois rape myth acceptance scale was not largely used in the Indian context, but out of the reviews of literature which I did, the scale was somewhat reliable. And since I wanted the questionnaire to be more understood by the masses, as I said, I back translated the tool as well in order to make it more easier to administer. And further researches, I would also use this scale, the translated version, and would formulate on its own with the help of my supervisor and check the reliability and validity of that as well. Thank you.
Thank you, Sanya. I do not see any other questions in the chat or in the YouTube section. So if there is anyone who wants to raise a question, you can do it.
If no one else has a question, I'll pose a question to the last speaker who talked about the couple's situation. In the UK, we have in the court, domestic violence court, the opportunity in case the court finds that one of the partners is committing a crime of domestic violence due to anger, they can put them on anger management training instead of a custodial sentence. Another India.
Professor Sarah, you're on mute.
I'm not sure whether in India you have alternative criminal paths to justice that correct that focus on correcting the criminal behavior. So, for example, if a couple in a couple you find that one is committing domestic violence because of anger, they can send them. The court can order that the perpetrator go on anger management instead of a custodial or non-custodial sentence. So my question to the last presenter, does India have So that was to the last speaker.
Dr. Sarah, I think she left the meeting, but somewhere I was associated with that work, so I might give the answer for that. If you are asking about the facility of anger management or something like that, I'm not that
Yes,
much
as
sure.
an alternative to punishment.
Yes.
Yes.
I'm not sure about any specific law or any specific provision, but in recent past, in our court, we have a provision of a counselor who has better knowledge of forensic psychology as well as clinical psychology. So whenever any case come to the court for example, divorce, and when they hear both the sides, and if judge found that this can be solved through the counseling rather than putting them in 6 months of that time period where they can live together and finally decide to be apart. So there are the positions of counselor in court itself, high court especially, where they have been recruited for the same purposes. That if such cases are coming, so rather than sending them behind the bar or giving the sentence of now you are aparted, they should go through the counseling process, or if any therapeutical procedure can be followed, it is done in India. And fortunately, one of our students is the part of such a system. So I personally know that it is happening here right now.
Okay. Thank you very much.
Okay,
Dr.
so
One sec, Sarah, if I can add to what Dr. Mishra was saying. Yes, here in India, the Domestic Violence Act per se is a protective one. It's not to punish; it's just to stop the violence. So before it goes to court, Dr. Mishra was talking about when it goes to court. But we do have the alternate dispute resolution, and we do have a family court where the judges, it's a more informal setup, restorative justice kind of a thing. So there are creative kind of suggestions given like this. Alcoholism, then you stop drinking if that is what is causing the violence. And anger, maybe also would be one of the issues that can be tackled.
What the courts do in the UK is that there is a budget for it, because the person has to. The course is mandatory. So that person, because I'm not saying he or she, because sometimes the female is the perpetrator, they have to go on an anger management course if the anger has been, because the partner may say she's such a good person, but when she loses it, I can't even recognize it. So then they address the anger, which is the root cause. So not really the restorative and non-restorative. That one is conciliatory moves. But I'm talking about addressing the root cause, because ideally they want that they don't want families to split and for the family to be together. But thank you very much.
all right. Professor Sarah, I have one last question for you from the chat. It's from Harshita. And the question is modern maritime piracy more dangerous than it was in ancient days?
Excellent question. And I'm glad you bring it up, because piracy is not new. Piracy used to happen. It's only now that it's criminalized. In the past, piracy, let me talk prior to the 19th century, they would attack ships, pirates being the illegal boarding of ships. They would attack watercraft, ships, boats, and so on, to steal the goods on board. Maybe someone was transporting some gold or some precious things. In South America, some of the piracy was motivated by, wanting to steal goods. So it was a crime against property. Yeah, they wanted to steal. But the piracy we saw in East Africa is a kidnap for ransom. When the human being becomes a commodity. In piracy in East Africa, the human being, the seafarers were a commodity. So the pirates wanted to take them ransom, which they did, and piracy began rising. So in order for them to speed up the process, they would torture the hostages. Now, this is where now it becomes a human rights issue, but also it becomes different from historical piracy, because historical piracy focused on the goods. They never did it to kidnap anyone to marry them. They didn't do it. But this one, they ensure they don't kill. Right now, they don't kill the hostages because they are bargaining chips. Their welfare becomes a bargaining chip. So to answer your question, the modern one is more dangerous. Also because they shoot at the ship. The pirates would shoot at the ship to slow it down. When they're shooting, they don't care who's behind the stern because it could get them. But also the hostage period is longer and longer. So to answer your question, yeah, the modern one is more dangerous. The weapons used and the commodification of the crew.
Thank you, Professor Sarah. And in the chat, I see a couple of articles that have been posted for you to look at. Okay, so with that, and also as you would be aware that the paper presentations are being evaluated, and for the benefit of the evaluator, I would like to reiterate the names of the presenters and their respective category. So we had 4 presentations in the student category. That is the students, Ms. Vidushi Sani, Ms. Mansi Trivedi, Ms. Sanya Kapoor, under the guidance of Dr. Nitesh Jha, and Mr. Hemant Sharma, and Ms. Japjot Kaur. And there were 3 papers by Mr. Ritin Joseph, Professor Sarah Simmons, and Ms. Priyanka Samuel, who belong to the professional category. So with that, I would like to hand over the virtual flow back to Kritika for any instructions for the sessions tomorrow. Thank you.
Thank you so much, sir. With this, we have come to the end of today's proceeding of the conference. We will have the second and the third session tomorrow from 10 a.m. Thank you for your time and for participating in this conference. Without your presence, this would have just been another conference. But now it is a platform to learn and share everything that we know now. And I think this was a successful session that we had. And hopefully tomorrow we'll have you and we'll learn, we'll have a platform to learn together. Thank you so much.
Sorry to interrupt. Could I just ask what, or rather, who was the third person to make the professional presentation? Sorry, I missed that in my notes I'm making.
So the 3 papers were by Mr. Ritin Joseph. The second was Professor Sarah Simmons, and the third one was Ms. Priyanka Samuel.
Thank you.
Dr. Viju, can you clarify about the research scholar? They do not come under the student category. The other category is for research scholars. So I think Mansi Trivedi and Vidushi Sani were research scholars, right? Were there any more research scholars? There are 3 categories.
Only 2 fit into the research scholar, that is Ms. Vidushi Sani and Ms. Mansi Trivedi.
Okay. Thank you. Kritika and Ritin, are you going to sign off and announce the time of the program tomorrow? Can you
Hello
thank the
everyone.
participants? And
So we'll just wrap up this session and everyone can leave the meet. And tomorrow we'll meet at 10 a.m. for second and the third session. The session will be from 10 a.m. to 5:30. And thank you so much for being present here for this wonderful session that we just had.
So it will be the same link for both the Google Meet and the YouTube, and it will be the same Google Meet link for both the sessions. So we'll meet tomorrow at 10 a.m. Thank you very much for participating. Thank you. We kindly request everyone to log out. Thank you.